My lords, kindly have to mention a matter, my lord, I'm praying for upgradation. My lord, items 43 of the regular list of.
But you have already mentioned without we granting leave. Yes, 43.
Yes, my lord, this is that mean profit matter which was being argued. Mr. Shobhoshachi Chaudhary had completed his submissions, and Mr. Thakkar was in reply.
Yes,
But
yes.
this has gone down the list, my lord. If any.
No, gone down because we tell you no why it has gone down. Now, appeal from decree and appeal from order will be rotated. Otherwise, we can't touch appeal from decree. Today, I believe appeal from decree has come up. Lucky.
Today is really the.
Yours is item number?
43 and 44. P. Thompson versus Raj.
এটা তো অনেক hearing হয়তো।
Any day next week, subject to my lord's business permitting, my lord, could it be taken up at 3 or any other time, my lord?
তুলে দাও যেগুলো শুনো।
Lordship. Grateful.
My lord, may I be permitted to mention, my lord, but I'm seeking for leave to file this appeal with.
When was the order passed?
24th June 2025.
When did you apply?
But I applied on 31st of June, 30th July. 30th June. Sorry.
Sure, not 31st June.
No. No, my lord.
Granted.
Diplomat.
Item number 1.
Why is this? This is assigned.
Yes.
No, assigned.
Yes. Lordship may kindly remember, this is a matter where, my lord, compensatory water body was created in order to, my lord,
One is Union of India. Yours is Taposh Kumar Ghosh.
Yes, I'm Taposh Kumar.
That's number 2.
Oh, sorry.
One nahi kyun? One to ki specially assigned. Na. So we mentioned to dekhti pachi madam. Oh. Acha. Very well. কিছু নেই ঠিক আছে পাস ওভার করো ফার্স্ট কলে Yes. Yes, more or less I remember. It's new to my lord.
Yes.
I was sitting with Justice Dotto.
Yes, initially the order was passed by my lord Justice Girish Chandra Gupta, as he lordship then was.
Yes.
Thereafter, my lord, after his retirement, my lord, bench was constituted, my lord, with
Justice Gupta. I was sitting with Justice Gupta then.
Yes, your lordship was sitting. Order was passed. Initial order was passed. Thereafter, my lord, the bench was constituted, my lord, with Justice Dipam.
Very well. Let this be listed under the heading contempt of court.
No, contempt disposed of.
But then what has come up?
My lord, the original writ petition.
Oh.
Contempt disposed of. Lordship disposed of the contempt.
Oh, I see.
Lordship, I can remember.
And what remains of the original writ petition?
Original writ appeal is, my lord, challenging, my lord, the unauthorized construction on a voter body.
Very well. Assigned matter bole ekta diye dio heading kore. It will be listed.
Lordship is passing any order, my lord, today.
Today? You want us to pass an order? We will. This matter has been assigned to this bench. Stop. The contempt application has been disposed of as we are told. Stop. Let the writ petition be, it's a PIL.
Appeal.
Let the writ petition, which is in the nature of a public interest litigation, be listed under the heading, key heading is dewe bola to? Assigned matter. Under the heading assigned matter on Monday thi lagi do. Monday. You please serve notice.
I'm having notice.
My lord, I appeal for the appellant. My lord, in this matter, my lord, corrections were to be made. My lord, department was to, my lord, effect the corrections. My lord, I believe, my lord, that has been done. There was an error in the cause title. My lord, this is an appeal under section 37 and refusal to, my lord, of the section 34. But my lord, I find that, my lord,
Before dismissed.
34 dismissed. So, my lord, I find that, my lord, there's no stay application. It's coming after a long time. My lord, I'll
Shall we simply adjourn it or what?
my lord, kindly grants me 2 weeks time to come up with a stay application, my lord. Because there's only the memorandum of appeal before your lordship.
What stay? The appeal has to be heard out.
Then, my lord, may I come back after 1 week?
No, you file a paper book then, informal paper
Yes,
book, incorporating all the papers.
Yes.
There's no question of stay.
Yes.
Your 34 has been
34 is
dismissed.
dismissed. my lord.
Esho.
Now, since they have not proceeded with the execution, my lord, we have also not filed the stay. So, in
Wow.
any event, the appeal
Very
has to be
good.
heard.
If you want to file it, we don't know.
Let us file paper books, my lord. Either way, my lord.
This appeal is directed against a judgment and order of the learned single judge of this court.
No, my lord. It's Alipur court.
Order of
My lord,
the learned trial court
additional district judge at Alipur.
of the learned additional district trial court, additional district judge from Alipur court, whereby the appellant's application under section 34 of the Arbitration and Conciliation Act, 1996, was dismissed. Paragraph. The appeal has to be heard out. Stop. Let requisite number of informal paper books be prepared by the appellant, incorporating therein all papers that were available before the learned trial court. Stop. All formalities are dispensed with. Stop. Let notice be issued to the respondents. One respondent or two?
My lord, only one respondent.
Respondent. Stop. Paragraph. List the appeal 3 weeks hence?
Not 4 weeks.
4 weeks hence, under the appropriate heading.
That will be your lordship.
ডেটটা দিয়ে দিও এই এদিকে এসো তো মাখুনি তো আপনার সেই লোশনটা কি হলো তাই রাখছো এখন নেই তো কেউ নেই ম্যাডাম পাস ওভার সিক্স
Yes, ma'am.
Restoration.
Recalling applications, my lord. My lord, here what happened, my lord? The order was obtained, my lord, without, with suppressing entire material fact, my lord, before your lordship. My lord, kindly take trouble to look at the order of your lordship, page 91, my lord.
Order dated.
Order dated
17th
my
of
lord, 17 June 2025, my lord.
Item number 6.
Calling
ये तो दिएছেন ভাই 7 এর ফাইল দিয়েছেন।
Last annexure, my lord.
Page.
Page 92, my lord, is the relevant portion, my lord, last page of the recalling application. There are 5, my lord.
You are a party in the contempt.
No, my lord. I contempt, my lord. Pradhan was a party. I am the person who was aggrieved by this order, against whom this demolition order was passed, my lord.
Maybe, but you were not a party in the contempt
No, my
application.
lord. That's a file recalling application, my lord.
In a disposed of lordship, contempt lordship, if
No, what can, this is not maintainable, sir.
My lord, kindly, my lord, see, my lord, two things I will show, lordship, your lordship. My lord, kindly see page, paragraph 5 once, my lord. We deduct the Pradhan of Maju Gram Panchayat.
may I submit one thing, lordship? I am appearing for the Panchayat lordship.
Yes.
Now, lordship, pursuant to the rule issued on behalf upon the lordship Panchayat authority, lordship, we pass the order and lordship sent for lordship taking necessary steps for before the lordship subdivisional officer.
You are
Now-
appearing for?
I am appearing for on behalf of the petitioner, my lord.
In
My
the
lord.
contempt application.
In the contempt application, my
Has
lord.
they served on you?
No copy has been served, my lord.
What, my lord? Serve first, then open your mouth. You are asking for recalling of an order passed on his application, and you will not serve him.
I asked my senior friend to take a copy. As he did not receive copy, I sent him to court.
Give it now.
My lord, I give it now, my lord.
Give it now. Come back day after Kobe? Tuesday.
Tuesday. My lord, one difficulty is that, my lord, kindly take place on 17, my lord, within 1 month, my lord, my structure will be demolished. My lord, it is your lordship's observation. Kindly take the. My lord,
Nothing.
my lord,
17 June order.
my lord,
My lord, not only that, in the contempt proceeding, my lord, he is not a party in this proceeding, my lord. His
This
application is not maintainable, my lord.
You make that argument next day.
Yes.
Take a copy.
Tuesday.
Grateful, your lordship.
This application has been taken out by the respondent number 9 in the writ petition, praying for recall of an order dated June 17, 2025, whereby a contempt application, you were the writ petitioner,
Yes, my lord.
filed by the writ petitioner, was disposed of. This bench,
My lord,
by this court.
my writ petition was disposed of by another bench. My lord, thereafter, my lord, appeal paper.
Stop. Paragraph learned advocate appears for the petitioner in the contempt application and says that a copy of the present application has not been served on him or his client. Stop. Let such service be effected in course of the day. Paragraph list this matter once again. Monday te diye dao, to hobe Mongolbar. Monday list diye dao.
Grateful, your lordship.
Under item 7, I beg to appear on behalf of the review applicant. My lord, on the last occasion when this application was taken up for consideration, leave was granted to the respondent municipality, since they wish to file a opposition to my Section 5 application. On Tuesday, I have received that copy.
You want time for reply?
Till Tuesday, my lord, till Tuesday, let it be listed on next Thursday, my lord.
Learned advocate for the review applicant
Petition.
says that the municipality's affidavit in opposition to the application for condonation of delay has been recently made available to him. Stop. He seeks a little time for his client to file a reply. Paragraph as requested by learned advocate, comma, let this matter stand adjourned and be listed again on Shamne Brihaspaতিবারের date দিয়ে দাও. Stop. In the meantime, the petitioner will be at liberty to file his reply with copy to learned advocates for the other parties.
And my lord, state is also appearing.
With copies too.
Grateful, my
My lord, we are for the municipal,
You are filing affidavit of service.
not affidavit of service.
Opposition.
It's an opposition.
Affidavit in opposition filed on behalf of the municipality be kept with the records.
I appear for the petitioner. This is my application for contempt. Not a little backdrop is this, my lord. Initially, there are 2 rounds of litigation by the petitioner. First round, my lord, they to RTI said we don't have the fund. We have not received the fund from the government. We cannot give it. RTI replied, we challenged. Honorable single judge said that no, non-receipt of fund or non-receipt of sanction is not a ground. You have to pay, pass a reasoned order. Remanded back to them. They passed an order. Now they said that ground is changed. They said that in the procedure of tender, there were some deficiencies. It was not properly floated. And there was some workmanship defect. So it cannot be given. I challenge that, my lord. The honorable single judge said that if there is any defect in the tender process, that is your problem. For that, the contractor cannot be faulted or deprived, and workmanship cannot be taken up at this stage of time. Against that, they preferred an appeal before your lordship's court. Your lordship will not upheld the order. That is, my lord, order in contempt. The lordship's upheld, my lord, and my lord gave 4 parameters. Just follow the parameters and decide whether you will get or not. And your lordship also clarified that after such a distant time, you cannot take up the point of workmanship.
What is your extent of your claim? What is the extent? How much?
Extent is, my lord, 60 lakhs, more than 60 lakhs, my lord, and plus interest, because 2015 the work was completed.
Mr. Banerjee, we have heard this on a number of occasions. Today, we will finally hear you and Mr. Mitro, and we'll reserve order. Becoming too much, either we hold him guilty of contempt, send him to jail or whatever, or we dismiss the application. So we have heard it more or less.
I'll just point out the 3 orders, my lord, the relevant portions of the 3 orders.
You want to file a very short note, giving the entire history, and which will make it easier for us?
I shall. About 4-page note, I'll file.
Page
Only one development, because on the last day, they said, during the contempt, my lord, they came up with the order. Your lordships are not satisfied with the order, because they took the same point again. Your lordships gave them a chance. They said, we shall reconsider. Then, my lord, they have conducted an inquiry, and a report is filed now. That report says that we can find the subsequent work which was conducted 2015 to 25. They are not doing the inquiry. They say the subsequent work we can find, but the work done in 2015 we cannot find that work. That is the report now they have filed. So they want to say that I have not done the work. So I have filed an exception to that, enclosing, my lord, the certificate of the concerned assistant engineer who has certified that the work was completed satisfactorily. I'll file the note.
File a note. Let us hear Mr. Mitro and reserve judgment after you file the note. Your client can also file a note if it likes. Yes. So then when will you file? Tell us. 1 week, 2 weeks?
Monday.
Monday week. Hearing is concluded for all practical purposes. Stop. Learned advocates for the parties wish to file short notes of argument. Stop. Let such notes be filed on the next date. Stop. List the matter under the heading to be mentioned. on Monday week, the bole dao date ta 21st. Only for the purpose of written notes of argument being filed.
Only one line submission. Their stand is that some order has been passed, so now you have to go for a fresh sheet challenging the order. My submission is that the order passed during the pendency of the contempt is not in tune with the order. Specifically, your lordship directed this can be done, this cannot be done. That has not been followed. I'll point out in my
We
note.
will consider.
Extremely grateful, my lord. Oh, 21 July. Tuesday week করে দিন স্যার
Monday week, Tuesday week. 21st July, I am told something of the other is there.
Actually, 21st July, হ্যাঁ। 21 করে দাও।
No.
21 কি?
21st is not Monday week.
21st is Monday week, so 22 তারিখ করে দাও।
Make it 22nd.
Extremely grateful, man.
Who is now, this is Howrah Municipal Corporation. Who is now the commissioner?
Lady Mayor.
No leniency for that.
Item number 10.
I beg to appear for the respondent authority led by Mr. Bihari.
My lord, I'm led by Mr. Devashish Kundu, my lord. He has humbly requested, can it be taken up on 24th, my lord?
Yes.
Lordship.
Fixed on any time, my lord, convenient to lordship's convenience, my lord. Then he could come and do it physically, my lord.
দেখো খাতাটা খোলো, 24 তারিখে খাতাটা খোলো। ফাঁকা আছে? Learned advocate for the appellant seeks accommodation. Stop. He requests that this matter be taken up on July 24, 2025. Stop. Learned advocate for the respondent has no objection. Paragraph lists this matter under the same heading on July 24, 2025, marked 3:30 p.m.
But if there is a resolution, can it be on
Thursday, why should there be a resolution? Normally it's Friday.
my lord?
Why think ill of somebody's health? Pray for everybody's good health and long life.
3:30. Great question.
Lord, in this matter, I am being led by Mr. Amit Nag, my lord. Lord, I am been instructed to ask for a short passover.
Kindly, my lord, Passover, I don't think kindly fixes a time and date, my lord.
Time,
Otherwise,
Mr. Banerjee,
This
time,
matter
then
not-
every matter we have to fix time. That is not possible. We fix time in very exceptional circumstances. We'll tell you when there's outstation counsel.
I
involved.
understand, my lord, but this lordship will remember, my lord. This is a very
What
short
is this?
issue with
Every
regard to-
time, every day. But you are assisting him. Why don't you do the matter? Look, for the last time we are adjourning it. Next day, come fully prepared and just do it. Whether
I am
Mr.
prepared, my lord.
You are prepared? You want to do it now or
Yes, I
Tuesday?
can do it.
My lord, just one accommodation, my lord. If on the next day Mr. Nag is not there, I will do the matter.
That's what we are saying.
My lord.
That's a gentleman's promise.
My lord.
You know?
My lord.
Again, accommodation is prayed for on behalf of the appellant. Stop. Learned advocate for the respondent is justifiably aggrieved. Stop. On several occasions, adjournment has been obtained on behalf of the appellant. Paragraph. Learned junior counsel appearing for the appellant assures us that on the next day, no further accommodation will be prayed for, and if necessary, he will argue the matter.
My lord.
Stop. Paragraph lists the matter on Tuesday, Shamne Tuesday, under the same heading.
15th.
Consult your diary.
No, I am there on 15th.
Yes.
Do it up. Grateful.
I'm grateful, my lord.
I'm leaving.
Second call. Yashudha Tanmay. This is an old appeal of 2024. Stop. The appellant has taken no steps in the appellants have taken no steps in the matter. Stop. The matter has been listed at our instance. Paragraph. In the first call, nobody appeared for the appellants. Stop. In the second call, also nobody appears. Paragraph. FMA such and such is dismissed. Stop. Interim order reform. Dismissed. An application to issue nahi. Take it.
So maybe on 17th instead of 15th.
My lord.
17th করে দাও, ওই যে আগেরটা.
Great.
In the usual order, in the first call, nobody appeared, huh? হয়ে গেল? এবার commercial. কেন 1 and 2 একসঙ্গে কেন? হ্যাঁ? Yes, item 1.
My lord, I am for the appellant. My lord.
Yes.
The inventory report has been submitted by the special
Oh,
officer.
I see.
And now, my lord, my prayer is my physical position, my lord. Prayer T, my lord. Now the prayer sheet.
If I may.
Yes, you will have to persuade us that the trial court had jurisdiction. That is the only point on which.
No, the trial court thought it did not have the jurisdiction
That's what I'm
because
saying.
the seat of arbitration is in Ranchi.
That's what I'm saying.
My lord, in
The
section
order-
9, your lordship knows, my lord, 2(1)(e) applies. Only in respect of section 34, that's the jurisdictional seat, as well as for section 11, but not in respect of section 9. Section 9, my lord, where the cause of action arises. My lord, admittedly, the cause of action has arisen in Murshidabad. So the learned commercial court at Asansol had the jurisdiction because it is in session.
Murshidabad will be Asansol
Yes.
court.
Yes.
Achha.
The court proceeded on the fact that since quoting all the judgments, that since section 11 and section 34 principles the court considered, did not consider 2(1)(e) of the act. That is the only point, my lord.
Let us do this. We'll direct physical possession.
Yes.
We'll dispose of the appeal with a prima facie observation that we'll have to set aside the order and remand it. Set aside the order of the learned trial court. And
But
ask
nothing remains in the section 9. Once the physical possession is taken, my only remedy would be before the arbitral tribunal
That's
against the respondent.
Very
Nothing
well.
remains.
Very well.
Nothing remains, my lord.
Very well.
Because assets admittedly belong to us. So all hypothecated.
From the very beginning, the respondents have not appeared.
Never appeared before the Asansol court also, because my lord, the respondent, my lord, has committed fraud, criminal cases pending against him. My lord, he has eloped, completely eloped.
Right, Arbitration Act like age.
But we have served the 21 notice. First time he received, second time my lord, another notice was served. It came back because he eloped.
Respondent has eloped.
Yes, he completely eloped, my lord.
With whom?
I do not know, my lord. But he has eloped, my lord. Even this exercise was, my lord, formulated
How
by
do
the
you know?
commercial. Lord, we are trying to get in touch with
But
him.
how do you know he has eloped?
Not test out.
He may have run away. He may have hidden himself somewhere.
Whatever, lordship. My lord. Section 11. Lord, whatever assets, my lord, the learned receiver has, my lord, identified, my lord, only in respect of those, my lord.
Keshav. Read orders dated June 10, 2025 and July 8, 2025. Paragraph. Today also nobody appears for the respondents. Stop. Learned advocate for the appellants tells us that the respondents were also not represented before the learned trial court.
No, pro forma respondent was representing, my lord, in the commercial court.
Acha, the respondents corona, the respondent number 1.
The pro forma respondent, because there's only one respondent, because the military
The
engineering
respondent was not represented before the learned trial court. Stop. The pro forma respondent was, however, represented. Stop.
they had only raised the issue of jurisdiction, my lord.
Paragraph. The learned trial court dismissed the appellant's application under section 9 of the Arbitration and Conciliation Act, 1996, solely on the ground of lack of jurisdiction. Stop. According to the learned trial judge, the seat of arbitration, since the seat of arbitration has been agreed upon to be where?
Ranchi.
Ranchi, the Asansol court would not have jurisdiction. Stop. Paragraph. We are of the view that the learned judge erred in so holding. Stop. The learned judge did not advert to section 2(1)(e) of the Arbitration and Conciliation Act, 1996, which reads as follows. 2(1)e টা set out করে দাও। 2(1)e আবার ব্র্যাকেটে I, শুধু ওইটুকু দিলেই হবে। 2(1)e I টা দিতে হবে না। Paragraph. Going by the aforesaid definition of court, the Asansol court would be the appropriate court since the entire cause of action
Arising in, my lord, within the district of Murshidabad.
Arose in the district of Murshidabad. Commercial, this is
It's a
commercial.
commercial dispute out of
Stop.
a agreement, my lord.
Commercial disputes arising in Murshidabad would have to be adjudicated by the commercial court in Asansol. Stop. Hence, we set aside the order under appeal. Paragraph. We direct the, given the conduct of the respondent, who has very carefully avoided this court, we are of the view that the learned special officer should take actual physical possession. Where will he keep them?
My lord, we'll hand it over to us, my lord. We will keep it in our custody because, my lord,
Yes. Don't do anything with it now.
these are all hypothecated, my lord. The only difficulty is that, my lord, if we do not deploy it.
Have you initiated the arbitration?
No, my lord.
Section 21 notice has been given.
We are about to file the section 11, my lord.
Without an award, you cannot do much with the machine. We have the view that the special officer should take actual physical possession of the equipment.
Equipments, my lord. There are different equipments, my lord.
Of the equipment and machinery in question, of which inventory has been made by the learned special officer. Stop. Paragraph. Accordingly, we direct the learned special officer to take actual physical possession of the concerned equipment and machinery and hand over the same to the appellants, who will keep the same in safe custody till the disputes between the parties are decided by the arbitral tribunal. Stop. It is made clear that till an award is passed in favor of the appellants, if at all, or at least without the leave of the arbitral tribunal, the appellants shall not deal with or dispose of the machinery and equipment in question. Paragraph. The appellants shall make all arrangement for the learned special officer to travel to the concerned locale for taking actual physical possession of the machinery and equipment. Stop. The learned special officer will be paid a further and final remuneration of rupees 25,000. No, this time it will be more work. 35,000. 35,000. Stop. Upon handing over the machinery and equipment to the appellants, learned special officer shall stand discharged.
Lord, if required, my lord, police assistance, because if required, my lord.
Stop. Paragraph. If the special officer apprehends any kind of resistance or violence, he will be at liberty to approach the jurisdictional police station for help, as also the concerned military authorities. Stop. If so approached, the officer in charge of the jurisdictional police station, as also the concerned military authorities, shall extend all cooperation and grant necessary protection to the special officer and the representatives of the appellants for the purpose of implementation of this order. Paragraph. The appeal and the connected application stand disposed of accordingly. Order to Job Baba. তো আমি জানি না যা করবে এটা করো না জাজমেন্ট তাতে এটা এটা
Appellate rules জানো তো?
But I appear for the respondent. But as far as
This is a matter.
uh, A is asking for, is that, my lord, I believe.
Did you recently go to Kashi,
But it is coming to me, it seems like. But as a matter of fact, I met Mr. Banerjee, Mr. Ratnakar Banerjee. He's moving around with a mask.
Oh.
So I thought that maybe I will not catch it.
The mask, he got it.
With the mask.
Yes, who's for the appellant?
I am for the appellant, my lord. This is an appeal. I'll point it out. This is an appeal, my lord, from an order of dismissing my Section 9 petition on the ground that under Section 11, the arbitrator has been appointed. Now, your lordship, on the first day, my lord had stayed that part and extended that order which was passed by the court. Now, my lord, thereafter, my lord, my learned friend could not appear, my lord. So on that day, your lordship.
See, what we had proposed, if I remember correctly, is we will extend the order for a limited period, let's say a month or whatever, and send it to the arbitrator.
Absolutely. I'm with my lord, but my only thing, what fell from my lord,
Yes,
with
my lord had
regard to,
taken
my
up
lord, order 41 rule 2, that I want to argue, my lord, that is
Order 41 will not apply.
Rule 11.
Yes. my lord.
Admission.
Yes.
Well, that will be your
is
lordship's
dangerous.
court.
I think I saw that.
My lord, I'll point it out.
That won't be this court.
I will
This
point
court,
it out,
my
my
lord.
lord.
This court
My
has
lord
to be-
kindly takes the practice rules. Bole di na.
Order 41, Rule 11, we have written
My lord
it.
kindly takes. My lord,
that will not apply. That principle will not apply.
আমি অন্য পয়েন্টে বের করছি। My lord kindly.
Who has taken the point that
Your lordship.
That's a judgment.
Yes,
my
yes,
lord,
correct.
in Murshidabad Zila Paris.
But my lord, I just point this out because Mr. Banerjee also thinks, my lord, we need to. My lord,
No, Mr. Roy, now that we have decided that, right
my
or
lord, it
wrong,
won't apply for commercial matters. My lord, kindly appreciate.
Absolutely, it won't.
It won't, my lord. May I just take your lordship to the rules of this court under the Commercial Codes Act?
Lordship.
My lord, Commercial Codes Act rules will.
Lordship can always revisit, my lord, if it is a point.
My lord, that is on a different point. My lord, that point was on the basis that it's a non-commercial matter.
See, that Murshidabad was non-commercial.
Non-commercial. This is a commercial matter. If it's commercial, my lord, under Rule 29 of the practice rules, my lord, of the Commercial Court, my lord, I've got two, my lord, copies.
Hey. Oh, we have it. What do you think? We don't have it.
My lord, the rules, my lord, that's why.
We drafted it. You were a member of that committee, no?
I think Mr. Shobhoshachi Chaudhary.
Yes, he was.
From the Parliament, my lord, as far as I remember.
Correct.
My lords will kindly take Rule 29. Commercial appellate rule, read with whatever. My lord, Rule 29(2). পরে apply করে এটা আমি কি করে pay করব? Commercial matter. When it's a commercial appellate division which will have the jurisdiction.
Under the Commercial Codes Act, my lord.
My lord, this is under the Commercial Codes Act.
Yes.
Commercial Codes Act under Section 16 will have, my lord, precedence over all the rules. Now, my lord, your lordships have framed these rules which says that the bench or the commercial court will, my lord, at the level shall follow the procedure laid down in the appellate side rules of the High Court at Calcutta, read with Order 41. So your lordships are the commercial court.
Only lordship will have.
My lord, the other court is not a commercial court.
Right.
So your lordship will have the
No, but if we follow the appellate side rules, then it needs admission.
No, it is to.
Well, even if it is admission, it's your lordships who will do it. Because your lordship is the commercial court.
Kindly sees the rules, my lord.
That is what is said.
Lordship will have to just read through it, my lord, procedural.
Well, your lordship will adopt that, but it is this court because that court will not have jurisdiction. With humility, I say, that is not a commercial division.
Erotic.
So for commercial matters, my lord, if we have a chance, my lord, you would like to argue on that one
That
also.
also, my lord.
But
That
my lord,
is-
for this purpose, my lord, commercial court, your lordships, the rules only say so, my lord.
And that also, my lord, if we get a chance in some matter, we'll argue, my lord. Perhaps, my lord, there is something which needed to be shown to my lord. But this commercial court, my lord, no way, my lord.
So my lord will kindly.
Why
Kindly
touch
clarify
this point at all? Did we raise this in any order?
No, my lord, your lordship just.
So then in this matter, why do we touch this point?
Because your lordship did not extend my
See, my
interim
lord,
order
in
on this.
every other matter, this may come up. And my lord, if it's not shown, then there might be an order which my lord will prohibit us from filing it before my lord. My lord, at least in this matter, lordship makes a note, my lord, so that we can carry it at least for the commercial matters. And then 37, my lord, will come and argue, my lord, later on.
Because my lord, on the last.
Shall we do that? We'll send it back to the arbitrator.
Yes, that part is all right.
Because your
That's
lordship will
fair.
again, my lord, renew that, grant that prayer again afresh, my lord.
Yes, we'll reinstate that order
Reinstate that, my lord, and.
for a period of 6 weeks.
Yes, my lord, I think on 17th of July is the
17th we have
next
a
date.
date, they can
My lord,
file
keeps
an
it for 6
application.
months, 6 weeks, my lord. And section 9 may be transferred there, my lord. I think that is what is generally done.
No, section 17, you file a.
We file a section 17 on the grounds.
Issue.
My lord, will kindly record since my lord, the affidavits are called for the allegation.
Yes, my lord, obviously I'm not opposing that.
Our attention has been drawn by learned counsel for the parties to an order passed by this bench on blank in the case of.
My lord, it's passed on 26th of June
And I have the
2025.
orders if your lordship wants.
Murshidabad Zila Parishad versus the Asian Healthcare Development Private Limited. खुले रखो, खुले रखो.
Wherein it was held, it was held that an appeal under section 37 of the Arbitration and Conciliation Act, 1996, other than an appeal under section 37 bracket 1 bracket choto c of the said act, would require admission under Order 41, Rule 11 of the Code of Civil Procedure. Stop. However, learned advocates for the parties in unison say that that may or may not be the case, that may or may not be, such admission may or may not be required in a non-commercial matter. Stop. In a commercial matter, such admission may not be required, and even if required, this is the only bench which can admit the matter under Order 41, Rule 11, Code of Civil Procedure. Stop. In this connection, learned counsel for the parties draw our attention to Rule 29 of the High Court at Calcutta, Commercial Courts Practice Directions, 2021, which reads as follows. এখান থেকে set out করে দেবে 29টা.
এটাও বার করে এই অর্ডারটা
Paragraph. Prima facie, learned counsel for the parties appear to be correct. Stop. This appeal will therefore deem to have been admitted, duly admitted. Stop. Paragraph. Now coming to the question of interim order, the learned trial court had dismissed the appellant's It now. Application under Section 9 of the 1996 Act for interim protection on the ground that an arbitral tribunal has already been constituted.
Appointed, not yet constituted.
Stop. We recorded in our order dated May 20, our order corona, V corona, a coordinate bench recorded in an order dated May 20, 2025, that prima facie the appellant has an arguable case in as much as constitution of an arbitral tribunal may not be a ground per se for not passing an interim protective order. Stop. Hence, we had passed an interim order, hence the bench had passed an interim order on that date. Stop. That order continued till the end of June, 2025. Paragraph. We are of the view that ends of justice will be served. No. We confirm our prima facie view that mere constitution of an arbitral tribunal is not a ground for refusal of passing an order under Section 9 of the 1996 Act. Stop. The proper course. No, stop.
Section 9.
When you applied under Section 9, there was no tribunal.
No.
Yes, that's exactly what I was saying.
Ah.
I will record that.
In this case, when the appellant applied under Section 9 of the 1996 Act before the Learned Trial Court, the arbitral tribunal had not yet been constituted. Stop. Hence, that was the only course of action, only course action open to the appellant. Stop. During the pendency of the Section 9 application, did the court initially pass an interim order?
Yes. That was the interim order, Your Lordship.
Acha, ki bollen na?
Extension was.
No. Extension was refused by Your Lordships.
তার আগে লেখো। The Learned Trial Court initially did pass an interim order in favor of the appellant, petitioner. Stop. Paragraph. However, during the pendency of the Section 9 application, on an application made by the appellant under Section 11 of the 1996 Act, an arbitral tribunal was constituted. Stop. When the Learned Trial Court was apprised of this fact, on that ground alone, the Learned Court dismissed the application under Section 9 of the 1996 Act. Paragraph. We are of the view that the Learned Trial Court ought not to have done what it did. Stop. The proper course of action would have been to extend the interim order for a limited period of time and relegate the issue of further interim order to the arbitral tribunal. Stop. We accordingly do so. Paragraph. The interim order that was passed by the Learned Trial Court and which a coordinate bench continued till the end of June, 2025, shall stand reinstated and shall continue reinstated forthwith and shall continue for a period of 6 weeks from date.
My lord, I wouldn't say the main seat for 8 weeks. I'll point out why, my lord. my learned friend's nominee is from Bombay.
8 weeks, 8 weeks.
Because we are having trouble with his dates, my lord.
8 weeks from date. Stop. In the meantime, the appellant will be at liberty to make an appropriate application before the arbitral tribunal for extension of this interim order or further orders. Stop. If such application is made, the learned tribunal shall decide the same in accordance with law after hearing both sides without being influenced by anything in this order.
Grateful, very grateful.
Paragraph, since we have not called for affidavits, the allegations in the application filed in the appeal are deemed not to be admitted by the respondent. Paragraph, the appeal and the connected application stand disposed of accordingly.
Grateful.
Miss Banerjee, my lord.
My lord, I appear online. My lord, I am ready in the matter. I had a leader, my lord, Mr. J, in the matter. Today, my lord, I have a 2:30. I am ready. I'll do the matter if I am not blessed with a
Only
leader.
one ray, my lord, Mr.
Yes, but there is, of course, my lord, now a change.
Yes, there's a development we have heard.
Yes.
So on that ground, we have to grant some time.
She will see the last order of the.
We have seen Mr. Ray did something yesterday.
But I apprehended this, my lord.
I also have a leader online, Lordship.
Online? Why? When will you all come?
I'll come, my lord. I have a. Any day your lordship fixes. Today I have a 2:30 p.m. fixed matter, my lord. Because of that, I am engaged in a conference. Your lordship will see the background, my lord. But I'll finish this and immediately come, my lord.
Come on Tuesday. Come next Tuesday. Do it.
But let it be understood on Tuesday they will do the matter, my lord.
Yes, of course. Tuesday ki jo nahi to.
No, Tuesday ki
Because your lordship has.
Sorry, I was asking my clerk.
Lordship has seen the last orders, my lord, repeatedly, my
Yes,
lord.
we remember. We remember.
It was dismissed for default twice, then again.
I have an extremely good case, my lord. I am not running away. I'll do the matter on Tuesday.
Of course.
This is the usual line of all learned state advocates. Very good case.
Mr. Sen was also on this side.
Mr. Sen, we'll just say not today. Oh, you want an order? Sure. Lekho. Learned advocate for the appellant says that although learned advocate for the appellant Miss Banerjee bole shuru karo. Miss Banerjee, learned advocate for the appellant who appears virtually, says that she's ready to do the matter. Stop. However, she had a leader in the matter who, for certain very recent developments, will be unable to appear in the matter. Stop. Paragraph. Let this matter be listed again on Tuesday, date diye dao. Retaining its position. Stop. It is understood that on that day, this matter will be heard out.
Deeply obliged, your lord.
Which one? Next one?
My This is my appeal. I must, my lord, at the outset, I point out that this relates to really construction of a contract.
Yes.
I have to demonstrate for your lordships that the construction by the learned arbitrators is not a plausible construction. That's my.
You have demonstrated, or you have to demonstrate?
I have to demonstrate.
Right.
That's my burden. Award, section 34 dismissed. Now we are in section 37 for your lordships.
You assail.
Yes.
You assail, you assailed
I
the
assail.
award.
I assail.
But that challenge has failed.
That challenge is, yes.
You want to begin? Begin. Your learned friend has come all the way from Delhi. Delhi.
See? Now, before I go to the award, my lord,
yes.
Lord, before I take my lords to the award, it, my lord, requires to be, my lord, probably appreciated as to how the payment in the contract works, because that's what it's about. Now, this, my lord, relates to SENVAT credit. Now, my learned friend's client is my contractor. Now, under these contracts, my lord, there is the clause, there are, my lord, several provisions, will of course, my lord, go there, that the contractor would arrange his affairs in such manner that a certain amount, say rupees 100, rupees 200, I get as SENVAT credit.
You have both filed your written notes of arguments?
Ready.
There was a direction of a coordinate bench.
But I don't
We find from the file.
Yes, there was a direction, but
Not filed.
not filed.
You have you
A minor ready. I can file them any time.
you will file after you argue.
Right. No. So, at the time of the input, when my learned friend's client is working the project, he pays the taxes, he raises bills upon me, I make payment, I make reimbursement of the bills. Now, the documents relating to SENVAT.
What tax is this? VAT?
SENVAT, VAT, SENVAT. Mainly
Central,
SENVAT.
central.
That is basically excise duty and
Yes.
service tax.
Yes, I'll come to that. I'll just.
They'll get input benefit by paying me.
Yes. Now, these documents relating to the SENVAT payment are forwarded to me, and I use these documents for obtaining credit at the time of my output. Now, the thing is, the payment terms are such that when the bills are raised, say, for example, if I may take an example, rupees 100 is for the work done in a particular invoice, and against that invoice, there is rupees 20 tax element, 100 plus 20. Now, under the terms, Lordship would find that I pay rupees 77.5 against that rupees 100. I hold over rupees 22.5, and rupees 20 as the tax element is concerned, I pay in full. I reimburse in full. What happens is, now Lordship knows these projects, there are several milestones. In our cases, there are what is called a preliminary acceptance certificate. There is the milestone of a final acceptance certificate, commissioning certificate. At the stage of milestones, I make the calculation as to whether the SENVAT credit that I am supposed to get, whether that level is being reached. Now, when I find that no, they are supposed to give me, say, total rupees 200 SENVAT credit, but they are only giving me, say, rupees 60. What I do is, from these milestone payments against the invoices they raise against this preliminary acceptance certificate, final acceptance certificate, commissioning certificate, I hold back certain amounts. I recover the shortfall that is there in the credit amounts. This is the dispute. According to my learned friend's client, if I may not put it according to my learned friend, because the project of course went on for some time, the tax regime changed, the tax rates changed. Therefore, instead of rupees 200 tax that they were supposed to pay and which I was supposed to reimburse, they had raised only a tax amount equivalent to rupees 100 upon me. So according to my learned friend, in any event, I had to pay him rupees 100 less what I could have paid him, because he has only raised bills upon me for rupees 100 tax. I say that the parties were well aware of this, and the parties knew that there might be change in tax, of course, there are tax rates and everything. Therefore, you had guaranteed the credit amount. And also the contract provided for that if there is a shortfall in this guaranteed amount, I can recover it. Unless, no, I understand because there are several similar but not same contracts. In another contract, in which I also, my lord, both of us on the other side, it's a different contract. Probably my learned friend is trying to point out that these are different, but I will point out. I'll, of course, my lord, have to point out those things. Now, I say that once you have promised that you have paid me this much Senvat credit, and this is not even an issue with short payment of tax or I am not making reimbursement, you have to make good on that contractual promise. This is not to do with really Senvat payment of tax or anything. This is a simple contractual issue. That's it. So this is the short compass on which this entire dispute and today we are.
This is a pre-2015 award or post-2015?
Post-2015 is secured. We have secured it.
Post-2015. So the scope of challenge is even narrower.
Even narrower. Even narrower.
So what do you want to show us first, the award or the impugned order?
Award.
Award. Show us the award.
It's the volume 1. Volume 1. Page 41. প্রথমেই আছে। And another thing I might point out, my lord, item numbers 4 and 5 pertain to different contracts, but the terms are the same and one award, which is before your lordship. So that's why lordship would find at page 41 at the top, ICC arbitration case number 25594 and then 25595. At the top at page 41.
Bridge and roof. How is bridge and roof involved?
41. Yes.
How is bridge and roof involved?
Bridge and roof is a party, my lord, but dispute is really between SMS and sale.
Award is against sale.
Award is against sale.
Not against bridge and roof.
Not really against bridge and roof. Yes. Now, page 41, lordship would find the parties. SMS and steel authority, they are really longer. Now, lordship would kindly come to page 50, the contracts are referred to 50. I'll just, my lord, run through this. 49 are who are the learned arbitrators. The arbitral tribunal, my lord, has been described at page 49. Page 50 are the contracts. Then lordship would kindly.
You nominated, there were two nominees, no?
Yes.
Nominated Justice Manmohan Sari.
Yes.
And they appointed Mr. Pradeep Kumar Mishra.
And both of them.
Mr. C.K. Sikri.
Yes.
Now, lordship would kindly come to page 63 because that really summarizes their case. So at one go, we have a bird's eye view of the entire thing.
Yes.
Page 63. Which was found?
Yes.
Summary of the claimant's claims and relief sought. Pursuant to the award of work and in terms of the agreement entered into between the parties, the contractor's obligation covered design and engineering, supply of technological steel structures, manufacture and supply of plant and equipment and commissioning spares, customs and port clearances, etc. as may be applicable in India other than withholding tax on design on engineering, supervision, training services as may be applicable in India, inland transportation, so and so. For providing these services, my lord, 5 lines from
Yes, yes.
For providing these services, a lump sum price was fixed. However, in the price schedule appended with the contract, this amount was further categorized into following elements: A, basic price; B, excise duty; C, central sales tax; D, value-added tax; and E, service tax, etc. Then, upon completion of works on 19th May 2019, the respondent issued a performance guarantee certificate dated 6/7/2019 to all the consortium members, including the claimant, certifying that all the works had been successfully completed. Accordingly, in terms of the contract, the claimant on 29 July 2019 submitted invoices towards 5% payments upon issuance of performance guarantee certificate. Out of the said invoices, the respondent withheld an amount of rupees 23 crores 93 lakhs odd. On 24 December 2019, the respondent informed that the said payment had been kept on hold on account of fraud.
Mr. Dasgupta, one second. Upon completion of work,
Yes. On 19th May 2019,
respondent issued a performance
have
guarantee.
the respondent in the certificate I would issue.
I demonstrate my
Yes.
performance of the.
He is my contractor.
project. They give me a certificate to that effect.
Yes.
That I have demonstrated.
No, respondent in the arbitration was Steel Authority.
Steel Authority. I am.
Oh,
Steel
you are
Authority.
the.
I am Steel Authority.
But performance guarantee certificate.
I would issue.
Okay.
When
I
I
would
demonstrate that the plant is running as per specification.
I see. Okay, very
So
good.
as my lord, may I, my lord, take a moment over here? As I was, my lord, submitting that these are milestone certificates: preliminary acceptance certificate, final acceptance, commissioning, performance guarantee certificates. So as I was, my lord, submitting, when we see this shortfall, we deduct or recover from these milestone payments. Here from the performance guarantee certificate, we have deducted. Out of the said invoices, the respondent withheld an amount of INR rupees 23 crores odd. On 24th December 2019, the respondent informed that the said payment had been kept on hold on account of shortfall in the amount of guaranteed SENVAT credit, which had not been passed on to the respondent by the claimant. So this is my defense, really, even today. The claimant protested against the said withholding through letters dated so and so, wherein it was explained that such withholding was not in terms of the contract. However, the respondent, vide his letter dated so and so, reiterated his stand and justified the withholding of the amount. In terms of Article 10 of the contract, this is really not really, my lord, necessary. Then Lordship would kindly come to summary of the respondent's claim and relief sought. The arbitration invoked by the claimant is time-barred, non-maintainable, and dehoves the contractual agreements and law. Contracts were awarded by the respondent to a consortium of 3 members, entities of which the claimant is one of the members. The arbitration agreement contained in the contracts provide for arbitration only between the consortium and the respondent. In the RFA, that is the request for arbitration, the appropriate law governing this arbitration proceeding has been agreed to be held under the aegis or under the Indian laws, and the settled Indian law prohibits arbitration proceeding being filed by individual member of consortium. Accordingly, where the parties to an arbitration agreement in their wisdom have agreed to enter into the agreement only as a consortium, clearly the obligation to arbitrate is between the consortiums as a whole, with the respondent on the other side. The claimant's attempt to individually invoke the arbitration proceedings is thus highly flawed, as is in contravention to the terms and conditions of the contract. Then, the claimant was awarded contract by the respondent after evaluating all bids received, including that of the claimant, net of taxes, as all the bidders, including the claimant, had, while quoting price under their respective bids, specified minimum guaranteed SENVAT credit. The bidders were to indicate minimum guaranteed SENVAT credit that can be availed by the respondent against material supplied for subject work and in case of any shortfall in SENVAT credit from that guaranteed by the bidder, the said shortfall shall be deducted by the respondent from the contract. In this case, the claimant failed to discharge his obligation to pass on the specified amount of SENVAT credit to the respondent. Not only has the claimant failed to perform his contractual obligations, but the claimant has unilaterally amended the contract price by nullifying the guaranteed tax credit, which has resulted into loss to the respondent and public exchequer. Further, in terms of the minimum guaranteed assurance given by the claimant under the contract to provide a specific value of tax credits, which is unconditional, the shortfall from such assured sum is recoverable by respondent from claimant as per contract. Therefore, the respondent is acting within the four corners of the terms and conditions of the awarded contract, has made payments to the claimants against the invoices received, and has recovered the shortfall that it has incurred from the assured sum of guaranteed credit. Since the shortfall in the tax credits have not been disputed by the claimant, the respondent is entitled to deduct the same from the payments due to the claimant. The claimant is interested in denying the right of the respondent to recover the said guaranteed sum under the contractual agreement. The respondent seeks the following relief by stating that the claimant does not have any cause of action against the respondent, nor does there is any alleged claim the claimant discloses the cause of action. Then, the last sentence, consequently, the respondent is also entitled to an award of the guaranteed sum less adjustments already made thereafter. So this is the conspectus of the dispute. Now, Lordship would find the issues at the next page. Now, for the time being, at least, my lord, issue 1, I am not really looking to. Then Lordship would kindly.
So what was the decision on issue 1? Yes or no? No. Then
Lordship would kindly straight away come to page 87. Before the learned judge, as also before your lordships, of course, my lord, I have not given up on that, but this is the main thrust, issue number 2. Main thrust, page 87. Issue number 2. Whether the claimant is entitled to the claims raised by it, if so, to what extent? The claims. The claimant has requested for the following monetary reliefs in both the cases. Lordship would find serial number 1 is the outstanding payment, 23 crores 98 lakhs odd, then interest, then costs. And Lordship would kindly turn the page. Clause 1.3.2 or L3.2, paragraph 85. There is no dispute with respect to the work executed by the claimant under the contract and the invoices raised in that behalf. It is also not in dispute that the claimant is entitled to these amounts as per the said invoices from the respondent, details whereof are mentioned in paragraph 1.3 of the statement of claim and accepted by the respondents in his certificate dated 24th December 2019. However, the respondent has withheld or deducted a sum of INR 23 crores odd from the invoices in the contract 1 which were issued and a subject matter of case number so and the sum of INR 4 crores odd from the invoices in contract 2 which were issued and subject matter of case number so. The reason for withholding the aforesaid amounts by the respondent is common to both the cases. Visibly under the contracts, the claimant had guaranteed a minimum SENVAT credit, but there is a shortfall in the amount of guaranteed SENVAT credit to the extent the monies are withheld or deducted by the respondent.
how does this SENVAT credit thing work? I mean, I'm not very clear.
May I try to the contract, I would show, I'll of course go to the contractual provisions, I have to show that. The contract says that your basic price, the consideration is the consideration is rupees 500. And apart from, in addition to rupees 500,
What is the nature of obligation of the respondent contractor? What is he required to do under the contract?
Because I have to set up 2 plants in the steel mill which they have produced. I am a company which is basically from Germany. I have the technology for these plants. So steel refining unit and the furnace, the huge furnace which is to be.
Right.
Those are the things that I am.
For that you will supply.
And also the civil works. That's why bridge and roof and all those are there.
I see. I see.
So the construction is carried out. I supply the materials and they are put on there. On those materials which are brought from Germany, nothing, no service, nothing, no taxes. But the materials which are procured or equipment procured from India, excise duty, and for the services I render from India, service tax is levied. The SENVAT rules came in, my lords, and they said if the employer has paid service tax. In this case, I paid service tax and excise duty on my goods and services. The employer reimbursed me. Steel Authority reimbursed me. So supposing I incurred 10 crore rupees worth of taxes on my equipment, they reimbursed me 10 crore rupees and then took benefit of that 10 crore rupees against their taxes, their output taxes, because they have already paid tax on the input. So they don't have to pay it again. So double taxation was avoided by the SENVAT rules. That was the entire concept of it. In this contract, the price was divided into 3 parts. Gross price, SENVAT, minimum guaranteed SENVAT, these are the words used. And then the net price. So let's say the net price is 100 rupees. SENVAT guaranteed is 10 rupees. The gross price is 110. So it's mathematics, 100 plus 10, 110. Now, when the contracts were entered into, the excise duty was about 12.36%. It went down to 10 and then 8. I couldn't chase after the government and say, no, you take more taxes from me. I would.
Therefore, the shortfall.
Therefore, the shortfall. And I admit the shortfall. There is no 2 ways about it. They also do not allege that I have somehow furthered or done anything. We are on a level which is where there is.
Right. You had no control over the reduction in the rate of tax.
I can't go to the government and say, hey, I promise somebody more taxes, so you may charge more taxes from me. The government charged me 5 rupees as taxes. I passed on rupees 5 to them. They reimbursed me to the extent of rupees 5, and they took benefit of 5. Now they are saying, and therefore the contract price came down to 105. Now they are saying because there is a shortfall and there is minimum and guaranteed SENVAT amount, it's written in stone, it cannot change. It cannot change. So there is a shortfall, you reimburse me.
We've understood. Thank you.
My response to Mr. Markanda's last part witness, it is written in stone. It is written in stone.
Very well. Yes, you continue.
Yes. Now, as apropos the query from my lord, may I only say this? 500 is the basic price consideration. Rupees 100, the contract says, in addition to rupees 500, first the contract says that all taxes are to be borne by the claimant, the contractor. But of some specified taxes, central sales tax, the SENVAT, excise duty, service tax, I would reimburse. First is I am not on guaranteed credit. I am on reimbursement. So in addition to rupees 500, which I would pay against the work executed, up till rupees 100, I will reimburse those taxes which have been paid by the contractor. That is the maximum limit. In contract, it is described as the ceiling limit. So 500, I have to pay, unless, of course, it's modified and all that. And apart from that, my probable maximum outflow is rupees 100. Now this rupees 100 is as far as the contractual pricing and all these issues are concerned. What is my outflow? The contract also says, and this is our argument, this has got nothing to do with the pricing of the contract. The contract says that the contractor would ensure that I get minimum guaranteed credit, SENVAT, VAT, for rupees 100. And Lordship would kindly appreciate, first, the contractual clauses have got nothing to do with each other. Second, that rupees 100, as far as the outflow is concerned, as far as the pricing of the contract is concerned, that concerns SINVAT, VAT, central sales tax, many other things, which is not within the credit regime. So, now contract was for 24 months, 28 months. Now the contract was for 28 months. So in 28 months, theoretically, every day the contract, the tax rates and everything can change. Every day, theoretically, it won't, but change. And my learned friend is right. There has been reduction in tax rates upon which, of course, neither my learned friend nor I, we have no control. But it is also a fact that tax rates have also gone up, gone down. Usual. None of us have control. So when the parties knew that it is not a one-day contract, it cannot be. That's, I thought, in 28 months, even within the original tenure of the contract, there could have been a situation that tax rates would change, that for the party, for the contractor, for no fault of its, could be in a situation that it is not able to provide me with the credit, SINVAT credit or VAT credit for that minimum guaranteed amount. That is the reason that minimum and guaranteed terms are used. Otherwise, it becomes completely odious, that part of the contract. Now, as far as the SINVAT credit rules are concerned, where all this credit regime and everything comes in, there is no dispute with the tax authorities. My learned friend, without making any aspersion, I would say, has presumably paid his taxes. I have reimbursed him also tax amounts. That's why, my lord, at the outset I submitted that when he raises his bills for rupees 100 and rupees 20 tax, I pay full against rupees 20. As far as rupees 100 is concerned, I pay rupees 77.5 because there are milestone payments. I'd hold back that. So tax, I reimburse him in full. It's not that I am not paying him tax amounts any less. I pay the tax amounts, whatever tax invoice raised in full. When I am making calculation at the end, then as loss to me, because the contract says so, because I am suffering loss for say rupees 20, because you have not been able to supply me with that guaranteed credit amount, I hold back rupees, whatever it is, the shortfall in the minimum guaranteed amount from the milestone payment. So tax invoices I have paid in full.
Are you not asking us to review the merits of the dispute?
No. All I am asking is, all today I am beseeching my lords is that the learned arbitrator, the interpretation by the learned arbitrator has rendered parts of the contract very relevant, admittedly very relevant parts of the contract odious. That is not a plausible interpretation.
Show us that portion.
Yes.
It's such a lengthy award, it seems.
May I show from the my lord award is the clauses are mostly there. Yes. Lordship would kindly come to page 92. In fact, before page 92, it would be Lordship's pleasure to come back to page 90.
Yes.
Lordship would find that the price schedule, so it's not a really good copy here. The price schedule has been reproduced here at page 90. Lordship has found. Yes. Now, Lordship would find
SINVAT credit.
Yes, total contract price, then SINVAT credit, then VAT. SINVAT credit, VAT and works contract credit, then total package price that is there. Now, Lordship would kindly turn to page 92. Lordship would kindly consider Article 2.1, contract price, at the bottom of that page, page 92. The employer hereby agrees to pay to the contractor the contract price in consideration of the performance by the contractor of its obligations hereunder. The contract price shall be the aggregate of euro so and so and Indian rupees so and so or such other sums as may be determined in accordance with the terms and conditions of the contract. Lordship would kindly note this. As may be determined, as may be in accordance with the terms and conditions of the contract. We'll circle back to this. The guaranteed amount of SENVAT and VAT credit to be passed on to the employer in Indian rupees is so and so.
552 million is 55 crore, is it?
Yes, 55.
We'll come back.
Yes,
Yes.
Page page 92, we are on.
Yes.
Lordship has seen clause
2.1.
Clause 2.1, Lordship has seen. Now, Lordship would kindly, before coming to page 93, Lordship would kindly consider page 94 first. I will come back to page 94. Clause 14.5.6. Lordship, fine?
Yes.
Contractors have indicated minimum guaranteed SENVAT credit that can be availed by the employer against material suppliers for subject work for which price quoted is in Indian rupees. In case of any shortfall in SENVAT credit from the value guaranteed by the contractor, the shortfall shall not be reimbursed to the contractor. In case employer is not able to avail SENVAT credit for reasons attributable to the contractor and the ED amount for such SENVAT credit has already been paid to the contractor as per the approved billing schedule, the same shall be recovered by the employer from the contractor. SENVAT credit in excess of the guaranteed amount will be shared in proportion of 50-50 between the employer and the contractor. Sharing of SENVAT credit as detailed above shall not include in SENVAT credit amount on account of statutory variation. These are really the clauses. Now, as against this, as far as the pricing is concerned, if Lordship kindly comes back to page 92, 92 bottom, 11.2.1. The contract price indicated in Indian rupees is inclusive of all taxes and duties and comprise inter alia basic price, excise duty, central sales tax or VAT, including sales tax, VAT, or contract for the erection portion of the contract only, octroi, service tax, education cess, and any other duties, taxes, and levies as may be applicable and prevailing on base date of contract. Lordship would kindly mark this on base date of the contract. While the basic price will constitute the consideration under the contract, the payment of duties, taxes, levies, etc. will be reimbursed on actuals paid against documentary evidence to be produced by the contractor, subject to a ceiling indicated in price schedule given in Appendix 1. In no case the reimbursement towards duties and taxes, etc., shall exceed the amount indicated in Appendix 1 towards duties, taxes, levies, etc., except as indicated in subclause 14.6.1. 14.6.1, Lordship would find at page 94, that has to do with variation of taxes and duties. Now, my lord, let's pause here for a moment. No, Mr. Basu is saying whether the other matters should be released because
you will continue till 1:15.
Least half an hour I will require, my lord, at least till 12:45.
You will reply immediately? So between the both of you, two of you, you will keep us occupied till 1:15.
Yes.
Release till 1:15.
Honorable. So, as far as the contract price is concerned, my lord, as I was, my lord, submitting as example, my lord, I was rupees 500 is the basic price, which is the consideration. Rupees 100 is the potential maximum outflow from me, which is described here as the ceiling limit.
That is Schedule 1.
That is Schedule 1. Ceiling limit is described, of course, in Schedule 1.
Appendix 1, sir.
Appendix 1. Now, Appendix 1, of course, now about Appendix 1. what Lordship is seeing right now in Appendix 1 at page 90, it is really, Lordship would find at the left top, summary of prices, page 90, which is the Appendix 1.
Yes.
Summary of prices. Now, this page I will show, this is really the summary page. Now, Appendix 1 consists of this summary.
With your notes, could you please file a more legible copy of this?
Yes, sir, we have right now. 184 Lordship can, 184.
184.
Yes. Yes, in fact, it's better. Mr. Basu has been insisting on showing that. 184, it's even better from there. Now, 184 Lordship would find summary price.
Yes.
Yes. Now, along with that, Lordship would find serial number 1, 2, 3, and in the description, Lordship would find design and engineering referred table 2B, 3B.
Yes.
Now, these tables are immediately thereafter, the next pages. Now, all these taxes, various taxes, as is applicable, Lordship would find that in the tables, these tax elements, whatever is applicable, that's described. The point is that first, the primary duty, I am either on this only for the reason because that is that has been the thrust of their argument. That's why I'm trying to also, otherwise. First, the primary duty to bear tax lies with the contractor. Second, I am to reimburse the tax borne by the contractor up to a certain extent, which is the ceiling limit, as described over here. Third, completely independent of this pricing mechanism, the contractor has, and there is no dispute about this, the contractor has itself indicated during the bidding that I would give you credit for, VAT credit for rupees X, whatever be the amount. Now, this rupees X, I did not get. I got rupees Y. There is also no dispute about these facts and figures, as my learned friend rightly pointed out. So, what I have done is, at the time I was making the calculation for the against payment to be made,
you deducted X minus Y.
X minus Y. That's why. That's what I have done. That's it. Now, according to the learned arbitrator, of course, which view has been upheld by the learned judge in course of section 34, I was not entitled to deduct X minus Y, primarily because I was not called upon to pay or reimburse tax amount X in the first place. I was called upon to pay only tax amount or reimburse tax amount Y because of whatever be the reason. And therefore, this is something I'm enriching myself, it may say so. I would not say unjust, but I am enriching myself.
You wouldn't say unjust.
I wouldn't say unjust. I am enriching myself. The simple answer to this, whether I know I might be, but this is my argument. The simple answer to this is
written on stone.
Yes, written on stone. Written on stone. It's a commercial contract. It's no question.
With eyes wide open.
Eyes wide open.
In their wisdom, the parties have agreed on a term. Yes. And so therefore, the sky may fall, the earth may perish, but that must hold good.
To be fair to my learned friend, because my learned friend, I was not there, my learned friend was there throughout the arbitration, I find out, because they did not raise any issue of, but they did not really seriously at least pursue any issue of unequal bargaining power, this and that. Formal, standard formal, they did not really. Somewhere I believe this somewhere there, but they did not seriously. So it's simply interpretation of the terms of the contract. And what is more significant is the contract, in the contract what is entitled as the contract document, as also the general conditions of contract, it says, there cannot be a dispute that any amendment to the contract has to be in writing. Now, one strand of the argument by the claimant has been that, look here, the taxes have decreased, I had to pay less tax, so the contract prices automatically change. Firstly, there is no question of automatic change under the contract. Second is, even if the contract price might have changed automatically, for the sake of argument, as far as the minimum guaranteed credit is concerned, you have never even applied for changing that. Forget about changing, ultimately both parties sitting down and say, okay, fine, we are amending the contract. Because the contract says that, okay, if the contractor wants some change, the contractor, usual contract would apply.
So in a sense, you're saying it was a strict liability, doesn't matter what happens. The contractor was bound to ensure that I get send back credit for 10 rupees and not 5 rupees.
Because the way it is couched, I bowed on my lord, the way it is couched in the contract, it is clear that it is treated as a loss that is occurring to the, otherwise it is loss occurring to the employer. Because, of course, parties knew that send back credit can only be credit. When the document is that tax document, whatever the way it be, when the tax document is being physically forwarded to me or electronically being forwarded to me, that can be only for whatever amount is being forwarded.
Why credit under the send back rules? Because otherwise it will amount to double taxation.
Double taxation. Now,
so even if it was not 5 rupees but 10 rupees as per the thing, you would have still had to reimburse him for the extra 5.
For the extra 5, subject to that ceiling amount.
Now show us the reasoning, how they have interpreted. We have more or less understood the point. Very short point.
Very short point.
Yes.
Now, Lordship would kindly come to page 103.
Is it raining in Delhi?
Not as much as Calcutta. Not as much as here. And if it does that in Delhi, it will stop working. We don't have the system to handle this much rain.
Last time it was pretty bad, the overflow from Jamuna.
That was very bad.
Delhi, 4.4.
When?
This early morning.
Oh.
No. May I proceed? Page 103.
Yes.
Tribunal's analysis. The tribunal arrives at a conclusion that even when there is a shortfall in the assured amount of send back credit, the respondent has no authority or power under the contracts to withhold or deduct the amount of shortfall from the invoices of the claimant. These findings are reached after examining the various contractual provisions. The discussion that follows in support of this conclusion would show that the tribunal has discussed this issue step by step under the following captions. Then, concept of send back credit. Before adverting to the main issue, it would be apposite to describe the send back credit conceptually. What is explained in the technical guide to send back credit published by the Institute of Chartered Accountants of India, which was referred to by the claimant at the time of arguments. Following passages in the said technical guide enumerate the nature of send back credit. In the year 2004, consequent to enactment of Finance Act 2004, the ministry issued notification number so-and-so dated so-and-so, whereby the earlier send back credit rules 2002 and the service tax credit rules 2002 were unified, and the new send back credit rules 2004 was introduced. The new send back credit rules 2004 contains 16 rules wherein both manufacturers and service providers are allowed to take input credit on goods and services apart from capital goods. The concept of send back credit. The send back credit scheme allows a manufacturer as well as a service provider to avail credit of duty of excise paid on inputs or capital goods and service tax paid on input services. Such credit could be utilized for payment of duty of excise on final products or service tax on the taxable output services provided by them. The concept of SENVAT scheme could be explained with the following example. Assuming excise duty is paid at the rate 12%. Then, my lord, the table is there. Then, it can be discerned from the above that the main purpose of giving SENVAT credit by the government is to avoid double taxation. The manufacturer of the final product, who may have paid excise duty while purchasing the inputs which are utilized in the manufacture of the final product, is supposed to pay the excise duty on the excisable value of this final product, which value is arrived at by including the value of inputs along with excise duty thereon. Duty of excise paid on inputs or capital goods and service tax paid on input services is given credit by the government under the SENVAT credit scheme to avoid double taxation, as the value of inputs on which tax is already paid gets added to the final products or output services which are subject to taxes. Thus, the employer, while paying tax on the output, avails the benefit of taxes paid earlier by his contractors or vendors on the inputs or capital goods. This avoids double taxation. Therefore, the duty paid at the time of inputs is refunded in the form of SENVAT credit and benefit thereof accrues to the employer. This scheme of SENVAT credit needs to be kept in mind while addressing the issue in hand. The structure of the contract price under the contract. It would also be necessary to understand the meaning that is assigned to the term contract price under the contract and the manner in which it is structured. That would bring clarity to many aspects surrounding the contract price and would also provide answer to the arguments of the parties premised on the clause relating thereto. Article 2.1 of the contract specifies the contract price in euro as well as in Indian rupees. It can be discerned from the reading of the contract that under the agreement entered into between the parties, the contractor's obligation covered design and engineering, so and so. Yes. Now, my lord, after the quoted part, or just before the quoted part. For providing these services, a lump sum price was fixed. This lump sum price was payable by the employer responding to the contractor. Pertinently, Article 2.1 of the contract prescribes the basis of this price as well. While giving the price basis, the opening sentence of Article 2.1 reads, "The employer hereby agrees to pay to the contractor the contract price in consideration of the performance by the contractor of his obligations hereunder." This very Article 2.1 also mentions the guaranteed amount of SENVAT and VAT credit to be passed on to the employer. The significance of this guaranteed amount of SENVAT and VAT credit would be analyzed at the appropriate stage, inasmuch as at this juncture the tribunal intends to explain the scheme of contract price. Constituents of the contract price. It is pertinent to point out that Article 2.1 of the contract makes specific reference to GCC Clause 11 as well as Appendix 1. Therefore, Article 2.1 has to be read in conjunction with GCC Clause 11 coupled with Appendix 1. Here, Clause 11.2 of GCC assumes significance because of the reason that it contains the basis of the contract price. Clause 11.2 of the GCC stipulates that the aforesaid contract price mentioned in Article 2.1 of the contract, which is indicated in Indian rupees, is inclusive of all taxes and duties. It is also stated that this contract price comprises inter alia, then basic price, excise duty, all that. Thus, all possible indirect taxes which are payable in the execution of the works are included in the contract price. In order to completely explain the manner in which contract price is structured and to put the things beyond any pale of doubt, the breakup of the basic price as well as taxes given in Appendix 1 to the contract itself. This appendix mentions various taxes which are payable. Insofar as the duties, taxes, levies, etc. are concerned, these are to be reimbursed on actuals which are paid by the contractor, and documentary evidence for such payment is produced. Two important features of this appendix are to be kept in mind. In the first place, it needs to be noted that this reimbursement of taxes is subject to the ceiling indicated in the price schedule given in the Appendix 1. The provision makes it amply clear that reimbursement of duties and taxes, etc., will not exceed the amount which is indicated in Appendix 1. That is also clarified in Clause 14 of the GCC. Secondly, Table 1B of Appendix 1 also gives the breakup of contract price. This is in euro as well as in Indian rupees with specific mention of the amounts in respect of each of the consortium members. Insofar as providing of design and engineering and supply of plant equipment and spares in euro is concerned, the question of Senvat credit does not arise and therefore it is not mentioned. In respect of the supplies by the Indian consortium members in Indian rupees, there is a specific column about the Senvat credit. Since the price includes all taxes, after stating the various components of the price from serial number 1 to serial number 13, total contract price is mentioned at serial number 14. Thereafter, at serial number 15, figures of Senvat credit are given. Serial number 18 mentions the total package price, net of Senvat, VAT and VAT on works contract. To sum up, the tribunal emphasizes that the contract price mentioned in Article 2.1 of the contract as stated in Table B. Therefore, thereafter, figures of Senvat credit are mentioned which are same as given in Article 2.1. Table 1B also specifically mentions the figure of the total package price, net of Senvat, which is arrived at after deducting the amount of Senvat credit from the total contract price. The portions of serial numbers 14 to 18 of Table 1B are reproduced below for better understanding. As can be seen, the contract price primarily consists of two elements, that is, the basic price, which is the consideration fixed for the works to be executed by the contractor, and B, Senvat credit, which represents the estimation of taxes that are payable and for which Senvat credit would be availed of. So, should kindly pause here for a moment. Contract price and credit. I mean, what this is happening with every matter. At first flush, it seems because the table in that summary table is described like that. First 1 to 13, 14, then credit. But price and credit are of two completely different genus. That is the summary price table. If Lordship considers the tables, the more detailed tables that are after that, Lordship would find, I will take my Lord to these tables, tax elements, say service tax, excise duty, octroi, whatever it is, those are described separately, and credit elements are described separately. So it's a summary table. What the learned tribunal is describing over here is only from that one summary table page. So just it's a summary table. It does not 1 to 13 of the price, 14 is the summation. After that, it says, it also mentions, it so happens, it also mentions what are the credits to be given. That does not mean, with greatest respect, that does not mean that the credits become part of the price. Credits can never become the part of the price. Credits are what you give, I don't know how to describe, what you give credit for after the price is paid, so to say. Credit is completely different. It so happens when summarizing the 12 or 13 odd tables in appendix 1B, appendix 1B in the summary page, which incidentally comes at first, it so happens only those numbers are mentioned, what is the pricing against each table, and the credit portion, because it is important, it is mentioned. That does not make the credit part of the price. Pricing is different. Credit is different. Minimum guaranteed credit is even more different, if I may say so. So the first inference over here that the contract price primarily consists of two elements might seem very innocuous, but the entire understanding, if I may so, my lord, is derailed from here. First is the basic price, which is the consideration, is fine. B, Senvat credit is not. That's where, with greatest respect, the problem lies. Part of the prices, at the cost of repetition, basic price, and the taxes, service tax, excise duty, VAT on works contract, VAT on input tax credit, otherwise, then octroi, then central sales, all these. Credit is something else. Credit is not part of the thing. This is complete misdirection of the thing, and this is not really a plausible interpretation. Credit can never be part of the pricing. Credit is different. Credit is what you give me as credit. But when the price is fixed, because the other clauses show is A, B, C, D, E elements.
Can't it be understood like this, that it's the basic price plus the tax element, which gives rise to this NVAT credit?
No. With greatest respect, my lord, I beg to differ. Basic price, then tax elements, all is fine. Now, Lordship would kindly consider the first few questions that fell from my lord, that this tax elements considered apart from this credit-worthy taxes, so to say, this excise duty, service tax, VAT on ITC, input tax credit, and VAT on works contract tax. These four, if I may say so. Apart from these four, there are several. Practically, the amounts are less compared to these four, but several other things. Octroi, many other things. If when I go to those detailed tables, Lordship would say. So the tax elements, part of which, yes, I bow down to that, part of which is relatable to the credit. But this, if where I, my lord, have to, I beg to differ is, it does not really, not as part of pricing. Not as part of pricing. I know it's a thin line, but there is a line. There is a line, if I may say so.
All right. Carry on.
Yes, next. These are the important features which depict the manner in which the contract price is structured and have bearing on the issue that confronts the tribunal. Concept of guaranteed amount of SENVAT credit. It is imperative to keep in mind the aforesaid scheme of the contract price, which mentions SENVAT credit as well. Now, Lordship, again, this sentence, what is in their mind? It is imperative to keep in mind the aforesaid scheme of contract price, which mentions SENVAT credit as well. Of course, it mentioned in the summary table. But if the learned tribunal would have taken they have seen, I'm not saying that they have not ignored document, I'm not on that. But if they have referred to the detailed tables, they would have seen that the credit elements are described separately, tax elements are described separately. It's a completely different thing. In this hue, it is imperative to understand the implication of the clause in the contract whereby the claimant has assured minimum guaranteed amount of SENVAT credit to the respondent. As already seen, the claimant accepts that under the contract, it was the obligation of the claimant to ensure that the respondent gets minimum SENVAT credit as mentioned therein. Insofar as the claimant is concerned, its share of assured SENVAT credit was in the sum of -1. It is also an admitted case that the claimant has not been able to provide documents to the respondent to enable the respondent to get SENVAT credit of the assured amount. However, the dispute is about the implication or consequence of such a shortfall, which is discussed hereinafter. In the aforesaid backdrop, the tribunal intends to refer to clause 14.5 of the GCC, which specifically deals with SENVAT and also provides answer to the issue at hand. Clauses 14.5.1, 14.5.2, and 14.5.3 stipulate certain obligations on the contractor, which are to be fulfilled in order to avail the SENVAT credit under the relevant rules. Clause 14.5.4, it basically Clause 14.5.4 deals with the supply of imported plant and machinery, which does not concern the tribunal in this matter. Most relevant clauses are clause 14.5.5 and clause 14.5.6. As per clause 14.5.5, the contractor is supposed to submit all relevant documents which are necessary to avail SENVAT credit. If there is a failure on the part of the contractor to submit the required documents, which results in non-availing of SENVAT credit, in that event, the employer is not supposed to reimburse excise duty to the contractor. Likewise, as per clause 14.5.6, when a situation results in failure on the part of the contractors to ensure minimum guaranteed SENVAT, such shortfall is not to be reimbursed to the contractor. These clauses are reproduced again to facilitate continuity of discussion. The clauses are set out. Then, 120, paragraph 126. Next. As can be seen, clause 14.5.6 of GCC of the contract also provides for both the contingencies. That is, where the contractor is not able to give required documents to the employer to enable the employer to get the guaranteed amount, and the SENVAT credit realized by the employer is lesser than the minimum guaranteed amount. This may happen in two situations. First, where the taxes paid are lesser than the amount of the minimum SENVAT credit stated in the contract. In that event, the credit availed would obviously be less. In the second situation, though taxes are paid, but documents to avail the credit are not adequately furnished, resulting in realization of lesser credit. That is the argument of the respondent itself. On the other hand, there may also be a situation where SENVAT credit availed by the employer is more than the guaranteed amount. It would happen when the taxes paid by the contractor are more than the minimum assured amount of the SENVAT credit. That is also dealt with in this clause. In case SENVAT credit is in excess of the guaranteed amount, the excess amount to be shared in the proportion of 50-50 between the employer and the contractor in terms of clause so and so. Thus, as per this clause, where minimum guaranteed SENVAT credit is not availed of by the employer, the shortfall shall not be reimbursed to the contractor. On the other hand, if the SENVAT credit is realized by the respondent is more than the minimum assured amount, the amount of additional SENVAT credit is to be shared equally by the claimant and the respondent. To sum up, the guaranteed amount of SENVAT credit requires minimum assured amount of SENVAT credit in the contract on the basis of quotation given by the contractor in the bid. The employer keeps in mind that it will be able to avail the stated figure of SENVAT credit. However, even when the contractor fulfills his assurance and enables the employer to avail the minimum SENVAT credit mentioned in the contract, the employer does not gain anything therefrom. On the one hand, the employer avails the SENVAT credit, and on the other hand, pays the very amount to the contractor in the form of reimbursement of the taxes paid by the contractor. The position remains the same even when the SENVAT credit availed of by the employer is less than the minimum guaranteed amount thereof, as mentioned in the contract. Advantage to the employer results only in a situation when the SENVAT credit availed of by the employer is more than the minimum guaranteed amount, as in the event the employer retains half of the surplus amount by reimbursing the contractor only 50% of the said surplus. This is their understanding, which is, I would say, there is as such no difficulty in understanding because it explains these clauses. There is no difficulty. But what follows from here, that is, having noted the aforesaid scheme, the tribunal proceeds to address the central issue. That is, what is the consequence of the contractor's failure to ensure guaranteed amount of SENVAT credit to the employer? At the outset, the tribunal would like to observe that the argument of the claimant predicated on double taxation is not tenable. It is because of the reason that because of the shortfall, the amount of taxes reimbursed to the claimant is also less, and it has to be so. This would not amount to deduction, and therefore question of double deduction does not arise. Similarly, argument of the claimant that clause 12.1.6 is breached is also not acceptable. The claimant has realized the payment of invoice but has withheld certain amounts. Therefore, clause 12.1.6 of GCC has no application. No doubt, the tribunal has come to the conclusion that such an action of the respondent is not justified, but this conclusion is reached on different reasoning. These are discussed hereinafter. As already noted above, it is an admitted case of the parties that the guaranteed amount of SENVAT credit by the contractor has not been passed on to the employer in both the contracts, and there is a shortfall. It is also an accepted case of the parties that the respondent is not responsible for this shortfall, as it has availed the SENVAT credit against the vouchers of the excise duties and service tax which was submitted by the claimant. Thus, insofar as shortfall is concerned, it has happened because of the inability on part of the claimant to provide the documents of sufficient amount to the employer for availing this credit. It is made clear at the outset that the consequences resulting from the shortfall are to be discerned from the provisions of the contract itself. The tribunal has noted that in many contracts entered into by sale with different parties, which contain the provisions relating to minimum guaranteed SENVAT credit, non-fulfillment thereof is fastened with different consequences. That will become clear when the contractual provisions in the present case would be contrasted with the provisions of the contract in Primetal's case. Therefore, the tribunal intends to proceed strictly in accordance with the contractual provisions in the instant cases relating to Senvat credit and the effect of non-fulfillment thereof. As already noted, the case set up by the respondent is that when a particular amount is mentioned as guaranteed amount or minimum guaranteed Senvat credit amount, some sanctity is to be attached to this obligation which is cast on the claimant. In fact, it is the claimant who had assured this figure in the bid tender submitted by it as a member of the consortium to the respondent. As per the respondent, while evaluating the tenders of the various parties, this was one of the crucial factors which was taken into consideration by the respondent. It is also mentioned by the respondent that the minimum guaranteed Senvat credit quoted by the claimant in the bid was the highest in comparison with other bids, when this is the purpose behind the provision stipulating minimum guaranteed Senvat credit. The respondent has a right to recover the shortfall from the claimant. Otherwise, it becomes otiose and is rendered redundant. That cannot be the intention of the parties, as otherwise there was no action and or reason for providing such a clause and making a demand on the bidders to quote minimum guaranteed Senvat credit. The aforesaid argument of the respondent appears attractive in the first blush. Generally speaking, when there is an assurance of minimum guaranteed Senvat credit by the claimant and it has failed to fulfill the same, one may not get persuaded by the one may get persuaded. Sorry. One may get persuaded by the argument that the consequence of non-fulfilling this obligation should be suffered by the claimant. Since the respondent was assured minimum guaranteed Senvat credit which has not become available to the respondent should be entitled to recover this shortfall from the claimant. However, this argument loses its sheen in the present case, having regard to the specific provisions made in the contract itself dealing with the consequences of the contractor's inability to provide the employer assured Senvat credit, resulting in a shortfall.
One second. Yes. Yes. Let us just sort one thing out. You will continue, it seems, till 1:15. Yes. And then what do you propose to do? Continue after recess, or will you complete today? Try to complete today if you can.
Manoj, I believe 2 or 3 more pages and then we are done. The reasoning goes up to page 116 basically.
No, I
discuss the Prime Metals case which was before the Delhi High Court.
I know this honorable division bench should give precedence with the utmost humility at my command. I might point out something. Post 2 p.m., there are some matters which got dismissed for default before a learned single judge. I have to be there. Lordship would kindly appreciate my predicament. Post 2 p.m.
No, but we understand that. So what do you propose? Because you must also keep in mind your learned friends coming from Delhi.
I would complete. I think by 1:15 I would complete.
You will complete. But then there are other cases which also require our attention.
I undertake not to take more than 15 minutes of my lord's time. Only the judgments have to show reasoning. I can't do better than them.
May I?
Anyway, you complete then.
Yes.
Your junior can be here, your learned friend can.
We'll submit a note shortly, and Lordship.
If you want to, really not necessary. This is such detailed award. Even a layman like me, who knows absolutely nothing about taxes, it's.
That is my argument. This has got nothing to do with taxes.
This is the contractual provision. Madam.
Yes, you're right,
Whether they
contractual.
should reimburse me or not to reimburse me.
The way the concept of SENVAT has been explained is very, very clear. You continue. Yes.
There is one side issue, though that's really not binding on your lordship by any event. I do not even want to say this aloud. Lordship would kindly take up the just for one moment. Pick up the memorandum of appeal once. This is volume 8. 8.
No, we have the memo. Tell us what you want.
Lordship would kindly the ground to good card. Huh? Lordship would kindly kindly count the good card. Lordship, should kindly keep the volume 8 with the lordship. I will continue with this. Only one thing I have to show from the memorandum of appeal. Only one.
From the grounds.
Grounds. One ground I will show. I do not want to. I'll just show. Place before your lordship. My learned Mr. Basu will anyway. Lordship would kindly, sorry. Lordship would kindly come back to page 112.
Yes.
For this paragraph 135.
Yes.
For this purpose, the tribunal would like to refer to clause 14.5.6 once again. This clause of GCC specifically caters to the minimum guaranteed SENVAT credit and contemplates both the situations, that is, a situation where there is a shortfall, as well as a situation which leads to availing of excess SENVAT credit by the employer. Effect of both the situations needs to be discussed together to arrive at a right conclusion. Clause 14.5.6 of GCC, in no uncertain terms, states that in case of any, as noted above, this shortfall can be for the reason that proper and valid documents are not given by the claimant to the respondent to enable the respondent to avail full credit. It may also be for the reason that excise duty paid was lesser than which was guaranteed. This clause takes care of both the situations resulting in shortfall of SENVAT credit. The stipulation that the shortfall shall not be reimbursed to the contractor applies to both the eventualities. Apart from this, there is no provision in the contract which entitles the employer or respondent to withhold or deduct the said shortfall from the amounts which are payable to the contractor under the claim contract. In the absence of such a provision in clause 14.5.6 or anywhere in the contract, it can safely be inferred that the respondent has no power or right to deduct the withhold the amount of shortfall in the SENVAT credit. Clause 14.5.6 of GCC thus provides the complete answer. The aforesaid construction of clause 14.5.6 of GCC gets strengthened when read in conjunction with Article 2.1 of the contract. Article Appendix 1 thereof, as well as clause 11.2 of 1 of the GCC, the scheme contained therein in respects of the contract price has already been described here above. The contract price is stipulated in Article 2.1 of the contract, and basis thereof price basis is mentioned in clause 11.2.1 of the GCC. It broadly comprises of two components: basic price, taxes and duties. I agree. I to that. This is fine. It is pertinent to state that this clause categorically mentions that the basic price will constitute the consideration under the contract. It is for the reason that basic price is to be paid by the employer to the contractor for performing its obligations under the contract. In that sense, basic price is static and firm, which reflects the compensation payable to the contractor for executing the works or jobs assigned to it in the contract. It has nothing to do with taxes or the SENVAT credit. On the other hand, insofar as duties, taxes, levies, etc. are concerned, they have direct nexus with the SENVAT credit. These duties, etc., are paid by the contractor to tax authorities, and the employer is supposed to reimburse that to the contractor. Such a reimbursement is against the actuals. To get this amount of taxes reimbursed, the contractor is supposed to furnish documented evidence to the effect that such duties, taxes, and levies are in fact paid by the contractor to the tax authorities. On the basis of these documents, insofar as payments of duties in the form of excise on inputs is concerned, the employer avails the SENVAT credit on the one hand and reimburses the contractor on the other hand. When read along with Appendix 1, the position becomes clearer. It gives the breakup of contract price. While total contract price is mentioned in Table 1B of Appendix 1, which is the same as stipulated in Article 2.1 of the contract, the amount of SENVAT credit is also reflected in this table. It further stipulates total package price net of SENVAT. It is this total package price which is the basic price and be described as consideration for the contract. Another significant aspect which needs to be highlighted is that insofar as reimbursement of the taxes are concerned, not only they are on the basis of actuals, Clause 11.2 of GCC also contains an important stipulations to the effect that the reimbursement towards duties and taxes, etc., shall not exceed the amount indicated in Appendix 1 towards duties, taxes, levies, etc., except as indicated in subclause 14.6.1 of the GCC, which deals with variation in taxes. Thus, even if the contractor pays the duties, taxes, levies, etc., which are more than the amount of SENVAT credit mentioned in Table 1B, it cannot get any reimbursement over and above the figure mentioned in Appendix 1. This reasoning of the tribunal gets strengthened by the latter part of Clause 14.5.6, which deals with the contingency where SENVAT credit availed by the employer is in excess of the guaranteed amount. In that event, the excess amount is to be shared in the proportion of 50-50 between the employer and the contractor. What is the effect thereof? In that event, the contractor will get reimbursement of 50% of the amount of SENVAT credit in excess of the guaranteed amount for the reason that Clause 11.2.1 entitles the contractor to get reimbursement towards duties and taxes subject to the ceiling indicated in price as mentioned in Appendix 1. To illustrate, suppose minimum assured SENVAT credit is INR 50 crore. The employer has been able to avail SENVAT credit of INR 60 crore, and the contractor shall be reimbursed INR 50 crore plus 5 crore, which is 50% of INR 10 crore that is in excess. Therefore, even if the contractor has paid duties, taxes, etc. worth INR 60 crore, because of which the employer has been able to get SENVAT credit of INR 60 crore, the employer reimburses the sum of INR 55 crore only. To sum up, the contractor provides for contract price and also gives the basis of this price by bifurcating into basic price and the duties, taxes, etc. No doubt, the contract also mentions the minimum guaranteed SENVAT credits that is assured by the contractor to the employer. However, in case of shortfall, the consequence thereof is also provided in the contract itself. To repeat, the only consequence is that the contractor shall not be reimbursed for the amount of taxes, etc., which it has not paid. According to the Learned Arbitral Tribunal, this is the only consequence. This clause nowhere provides for deduction of or withholding of such a shortfall from the basic price, which is the consideration payable by the respondent to the claimant under the contract. Once the matter is examined in the opposite perspective, the tribunal gets answers to various other arguments raised by the respondent as discussed below. The respondent has relied upon clauses 14.6.2 and 14.6.3 of GCC on the basis of which argued that in the event there is a change in law which results in increase or decrease of taxes, the contract price can be changed, and the claimant has neither produced an evidence indicating variation in the rates of excise duty and service tax, nor made any request for change of contract price. However, as can be seen, the issue does not pertain to change of contract price. The claimant has not founded his case on the basis. In fact, the claimant has accepted it has not been able to assure minimum SENVAT credit for the respondent. The precise issue is the effect thereof and whether in such a situation, the respondent would be entitled to deduct the amount from the consideration payable to the claimant as basic price. According to the tribunal, such a course of action is not permissible in the absence of any contractual provision, as well as in terms of clause 14.5.6, which provides for the non-reimbursement of the said amount in the eventuality of shortfall. Having regard to the aforesaid analysis and approach of the tribunal and the conclusion that consequences of non-fulfillment of minimum guaranteed SENVAT credit are provided in GCC clause 4.5.6 as are the provisions. Reliance of the respondent on the judgment of the Supreme Court in so and so is of no consequence. It is not a case where the contractual documents do not bear clear meaning and tribunal is supposed to make an effort to assign some meaning. The contention of the respondent that the contract was awarded after taking into consideration the minimum assured SENVAT credit offered to the claimant is not borne out from the records. On the contrary, the bid data sheet, which was enclosed along with the bid documents and was relied upon by the claimant during arguments, categorically stated that the price evaluation would be done on the net price without taking into consideration SENVAT, as is clear from the following submission. The rest part, my lord, I will of course I can show that, but that is really negating my learned friend's argument. So that is, I am not agreed by that. Now, apropos this, Lordship would kindly again turn back to the contractual clauses once more, just once more. আমাদের স্টেটমেন্ট অফ ডিফেন্স টেবিল করলাম First, page 92. What should I say?
Yes.
2.1, the last part, the last 3 lines, last sentence. The guaranteed amount of SENVAT and VAT credit to be passed on to the employer in Indian rupees so and so. This is one. Next, Lordship would kindly turn to page 94.
Hmm.
.5.6. Contractors has indicated minimum guaranteed SENVAT credit that can be availed by the employer against material supplies for subject work for which price quoted is in Indian rupees. In case of any shortfall in SENVAT credit from the value guaranteed by the contractor, the shortfall shall not be reimbursed to the contractor. This is what the learned tribunal is on. The next part. In case employer is not able to avail SENVAT credit for reasons attributable to the contractor and the ED amount.
What is the ED amount?
Excess duty.
Excess duty.
And the ED amount for such SENVAT credit has already been paid to the contractor as per the approved billing schedule. The same shall be recovered by the employer from the contractor. Now, this is where I have said this, my lord, but how the payment is made, that assumes significance. To it the contractor there.
Is it your case that you have paid this amount?
Yes. That's what my lord has submitted outside. They raise bills. I make payment against the bills. Rupees in these bills, say rupees 100 is the basic price or basic price. Rupees 20 is the tax limit. I contractually am obligated to pay rupees 20, the tax limit in full. And rupees 100, I pay rupees 77.5, 22.5 I hold back because I have to make this further payments. It's there, I'll show in a moment. I make all these payments against these bills at the final stage, that is performance guarantee certificate in this case, or maybe against sometimes in PSECC, all this. When I make the final calculation that how much credit I have received, tax I have already reimbursed, how much credit I have received, I find that an amount of say rupees 100 is outstanding. From the amount payable against the performance guarantee certificate, invoices raised, I have recovered this rupees 100. taxes I have already paid, I had to pay. Now, Lordship would kindly take up, this is volume 2. That's why, my lord, I say that. Page 207. Page 207. That's why I said at the outset. Lordship has found the terms of payment.
Yes.
Now, Lordship would kindly turn the page. Kindly turn the page. Page 208.
Yes.
Clause 2.1 is the terms of payment for the items other than training. I will just read through it so that it's coherent. 2.1, 5% of the total contract price shall be released to submission of the following, then 5%. Then 2.1.3, Lordship would find 77.5% of the contract price specified in Appendix 1, excluding taxes and duties, shall be released towards progress payments, these bills. Lordship has found. Then Lordship would find 2.1.4, 2.1.5, 2.1.6 are all these milestone payments. 2.1.6 concerns performance guarantee certificate. 5% of the contract price specified in Appendix 1, excluding taxes and duties. That's the significance. And training charge shall be released after establishment of performance guarantee parameters and issue of performance guarantee certificate. So the 22.5% I hold back from this, it's not technically RA bills, progress payments. These are spread over these milestone payments. Now, Lordship would kindly, yes. 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 2.3.3.1. Page 209. (77.5% of the price specified in Appendix 1, which Lordship has just now seen, corresponds to the previous page 2.1.3. Along with 100% taxes and duties shall be released on pro rata basis as per agreed billing and whatever. So when the bills, these progress payment bills, if I may, for the timing, my lord, refer to them RA bills, it is easier to refer to. When these bills are raised upon me, I pay 100% of the taxes and duties and 77.5% of the basic price. Because Lordship would kindly appreciate, there is no dispute that I had withheld any amount against these bills. Now, again, if Lordship turns back to 208, Lordship would kindly turn back to 208. These progress payments.
These 100% of the taxes that you reimbursed,
yes,
you didn't get the documents for that?
Yes, I've got.
Then
100% taxes and duties, they have only given me those documents which they have got.
of course.
Yes.
Well, they can't manufacture documents.
No, that's not nobody's case. Now, what all I am saying is taxes and duties I have already reimbursed. Because the question that fell from my laws was that whether I have tax and duties I have paid. Yes, I have paid.
What you have paid for that, you have also got the credit.
Yes. Now the question
Shortfall is because the rates fell,
yes,
and therefore the outgoing on account of SENVAT from the contractor that did not reach the minimum guaranteed level.
And there the contract kicks in.
There?
The contract kicks in. The contract says I have right to recover.
No. Anyway, I'm not arguing with you.
No, Lordship, I am not. Now, Lordship, that is the import. Lordship would find again at that 14.5.6. In case employer is not able to avail SENVAT credit for reasons attributable to contractor and the ED amount for such SENVAT credit has already been paid. That's where my last question was. That whether I have paid the ED amount. I have paid the ED amount. ED amount has already been paid to the contractor as per the approved billing schedule. The same
The amount for the SENVAT credit relating to the SENVAT credit. It is not your case that you have reimbursed anything for which you have not got the credit.
No, I cannot.
You cannot.
Because
if that is so, then how can you deduct?
No,
Because there's a shortfall.
Yes.
Whether the contract permits you to do that?
Yes.
That is the question.
That is the question.
Very well. We have understood your
Now,
argument, Mr.
only
Dasgupta.
one more thing. Again, my lord, at the cost of repetition, but because this is my case, the learned arbitrators did not really consider this way. In case employer is not able to avail the SENVAT credit for reasons attributable to the contractor, and the CD amount for such SENVAT credit has already been paid to the contractor as per the approved billing schedule.
What is the reason attributable to the contractor in this case?
Reasons not attributable to me.
What is the reason attributable to the... You just read a clause.
Yes.
I'm asking you the meaning of it. What is the reason attributable to the contractor in this case?
They did not supply me with those documents.
Just now you said you have got all the documents.
No, they did not supply me documents for the entire amount.
How can they, if they have not paid?
So that is my lord, that is not attributable to them.
That is their fault, if they have not paid.
That is
Because the taxes have fallen, they have not paid, that's their fault.
No.
Some reasonable construction has to be given, Mr. Dasgupta. Stone, iron sheet, whatever, wherever it is written.
No,
Anyway,
the thing is,
it's your argument.
in
We
their
have understood.
in their
We will
arbitration,
rise now. We will rise now because we are also hungry. Will you? You can't continue, but you have finished, no?
I have finished only. I want to just. I wanted to just show the.
If you can persuade your learned friend to stay back in Calcutta today, we can finish it off tomorrow. Otherwise, we could finish it off at 2 o'clock also, provided he is available.
I'll be here tomorrow. I'll be here tomorrow.
How much longer he will take?
Maybe 10-15 minutes.
15 minutes. He will take at the most half an hour.
Not more than that at all. Whatever I have to say, it's all there in the.
Hey, kalke khatara koro. Paka? Paka? We'll fix it at 12:30. So both of you, between the two of you, you get 45 minutes.
10-15 minutes at the most.
Highly appreciate.
Mr.
For both the cases.
Written notes of arguments filed on behalf of the respondent in both the appeals be retained with the records. Paragraph, Mr. Dasgupta, learned counsel, representing the appellant, has argued at length. Stop. He has, however, not concluded. Paragraph. Let these matters be listed again. Kalki did on such and such, marked 12:30 p.m. Thank you.
May I seek one indulgence? Nothing to do with this matter.
Yes.
The next matter is also mine.
Next matter is also yours.
Yes.
Which is that matter?
That is also same litigant.
Daniel. But who is on the other side?
I'll inform. Mr. Hariram Singh is the advocate on that.
Inform.
Please stand over for the next.
Okay, stand over till July next week. কত হচ্ছে?
Next week.
July 18, 2026. Is that all right? The date is all right. July 18, 2026.
Apart from July 21, I believe all dates.
July 18, 2026.
No, that is not all right.
Repeating for you.
I'm sorry, I know my laws are rising. I've just received my office is listening in, of course. They've just sent me a message. Tomorrow case is listed in the Delhi High Court. Could it be Tuesday, madam?
Yes.
Be back on Tuesday.
Yes. তাহলে ওটাই করো টিউসডে খাতাটা দেখো হ্যাঁ 12:30 is free. টিউসডে, ওটা টিউসডে ডেট কি হলো? আরে যেটা যেটা আমি কালকে রাখতে বলছিলাম সেটা, সিক্সটা না, সিক্সটায় তোমার কিচ্ছু করতে হবে না, কিচ্ছু লিখতে হবে না। টিউসডে।
Highly pledged.
I have a very good friend in the Delhi High Court. Very, very close. Justice Pratik Jalan.
Absolutely, my lord. He's a brilliant, brilliant.
Yes. All right. See you on Tuesday.
Grateful, my lord.
Beyond said matter, court judgment, item number 1.
Hmm. কয়েকটা তো কথা বলো। Mr. Kaur, health-wise, you are all right?
Can't be blood. I am 83.
No, you're joking.
I am not.
You don't look a day older than 70.
I am 83 plus.
My God.
Escape routes are quite quick.
Yes. Do you know he was an excellent cricketer?
Sir.
I have seen him bat.
Lord, may I go through the judgment?
This appeal is allowed, sir.
Yes.
The counterclaim has been found to be not maintainable.
In this court. In this court. It will be uploaded within the next 1 hour.
Lord, what I was praying, subject to Lord's pleasure, this will not prevent me from filing a fresh suit.
Yes, we can add that.
Yes.
Hey, acha add করে দেবো. We'll add that. একটা line add হবে. This judgment and order will not stand in the way of the respondents agitating their aforesaid counterclaim before any other forum in accordance with law.
I make one humble submission subject to my lord's kind approval. If your lordship kindly records this line as the submission of the
it's a finding.
No, it will not really. How can we stop him from before the appropriate forum?
This was a submission and for which your lordship has included this line.
Very well. তাহলে এটা করো। After delivery, এরকম ভাবে লেখো, after delivery of the judgment, comma, Mr. Kaur, comma, learned senior counsel representing the respondents says that it should.
Defendant, respondent number 6.
Respondent number 6.
6 Roman 10. I think he's only appearing for 6 Roman. The
2
others,
and Roman 6.
only one defendant.
Number
6 Roman 10.
6 Roman 10. For the respondent oblique defendant number 6 bracket Roman 10 says that this judgment and order should not prevent his client from agitating his counterclaim before the appropriate forum. Stop. We clarify that this judgment and order will not prevent the defendant number 6 bracket Roman 10 from taking recourse to any other forum for enforcement of his counterclaim as he may be entitled to in accordance with law. We'll add this. এখন করো না, পাঠিয়ে দাও, আমার চেম্বারে পাঠিয়ে দাও।
I'm grateful to you.
এটা এই লেটার বলে যেমন দেয় আফটার ডেলিভারি, তো এটা বলে দাও।
Commercial, item number 7.
Mr. Proneet Park is appearing for the appellant. I have been informed he has some medical emergency in his family and he's not in court today. As such, I pray your lordship kindly keeps this matter on Tuesday.
On the ground that there is some medical issue in the family of learned arguing counsel for the appellant, comma. Adjournment is prayed for, paragraph. List this matter once again on Tuesday, Tariq Dida. হয়ে গেল?
New application audience side matter, item number 2.
I get to appear in person as appellant in this matter. My lord, this matter relates to a partition suit, wherein, my lord, the two defendants, number 1A and 2C, demised. It's a partition suit of 2005, wherein original parties have demised, or thereafter their heirs were added. Now, after addition of the heirs of those deceased, my lord, again defendant number 1A demised on 13th March 25 and defendant number 2C demised on 4th July 24. No.
This is the substitution.
No. This is about, sir, please, 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 this is my appeal. Every time they interfere, my lord, and confuse the honorable court. Now, what has happened, my lord? The amendment carried out in the execution case. Now, after this amendment, they are not supplying the execution amended petition, what they have done previous. Now, I prayed before the learned executing court to serve us the amended copy of the execution petition. The learned court ultimately, I preferred the appeal. Thereafter, on the last date, 30 June, directed them to serve the copy of the amended execution petition after filing this appeal. Now, also, they are not taking step for filing substitution in the suit. Now, in this suit, earlier, they have also substituted the heirs of the original parties and served the amended copy of the plaintiff in 2019. Now, today, they are not taking step. Now, Lordship, kindly visualize the position.
So what can we do as the appeal court?
Lordship, kindly hear me, my lord, for a minute. Now, they have filed an application for change of address. Now, there is no meets and bound partition printed. Now, if any order is passed under the law, I have to apply for the certified copy. Now, this certified copy, we need to endorse a certificate in the application form of the certified copy that the cost title is true and correct. So, unless I get the certified copy, I cannot apply for. So, they will execute and go on, and I cannot prefer any appeal. Now, today I prayed before the court then the court said, yes, you take step in accordance with law. Now, based on the amendment carried out by them, although I have no copy of the execution petition with me or any substitution has been filed by them, I preferred this appeal based on the amendment carried out in 2019 by the plaintiff themselves and what application for amendment they have given to us, based on which the amendment application allowed by the learned executing court. I preferred this appeal with the leave of your lordship, that without certified copy. And I have annexed the orders that days together the address change application GA10 is being heard out. Now, next date is on Monday. Now, my lord, my predicament is today, if any order is passed, I am putting this question to myself. I cannot apply for certified copy, nor I can prefer any appeal. Now, your lordship, of course, may put a question to me, how we have preferred this appeal. Now, this is the circumstances I stated in my petition, and the synopsis your lordship will find that in this background, I never heard that the amendment, without serving the copy of the amendment application, the executing court can proceed or the plaintiff can pursue their case. But this is the all long and short question issue is involved in this appeal. Now, additionally, the corporation who has been added as party, rather added as special statutory body to look after our this meets and bound partition, how can be constructed and how the lot A, B, C can be divided. Now, therein, my lord, when the heirs of the defendant number 2, who demised on 30th May 2008, the court directed the plaintiff to take step in accordance with law, that is the substitution. That was not made. On verbal prayer in 2019, after about 13 years, they were added as party, which is basically section 21 of the Limitation Act. Now, such addition is, my lord, in my respectful submission, is a prospective one. Cannot be retrospective one because that addition has not been made either based on any substitution petition or any kind of petition. Now, be that as it may, we want to solve this problem. We, Lot B, I am for the Lot B with my brothers. My elder brother demised. Now my younger brother is there. The heirs of the elder brother has been added in the executing court, not in the suit. Now, in 15th November 2019, the executing court itself directed the plaintiff to serve copy of the amended petition to the corporation. Now, today they cannot do because new party have been added. Now, my lord, in these circumstances, everything has been stuck up. So, my lord, let the plaintiff serve the copy of the execution petition upon me and file a substitution petition in the suit so that the everything can be solved. This is the only issue involved in this appeal. If your lordship want me to elaborate, my lord, I can show it.
May I just say one thing, my lord?
Which is the impugned order? This is an appeal you have filed.
This is not the impugned order is as such not there, but the direction is being given. Last order I cannot annex.
There is no impugned order, then how will this appeal lie?
My lord, that is the, for the first time, my lord, for the first time I am facing this problem.
Sorry, sir, we can't help you.
My lord,
go and file an application, then formal application, get a rejection, come up.
Even to file an application, I need the cost title. That is a difficulty, lordship.
File with the present cost title, with short cost title. We are not there to advise you, sir.
No. That
if you are not challenging any order, then this appeal doesn't lie.
No, lordship, may I show one order, my lord? The learned executing court directed me to take step in accordance with law. So the learned court ultimately, when the appeal is pending, passed order on 30th June. Directed them to file the copy of the amended execution petition.
Fine, now that order is there.
One order is there.
Either they comply with that order or they challenge that order.
I have obtained for certified copy of the amended, my lord, cost title as soon as that.
Why certified copy? Give them just a copy.
Yes,
my lord.
I'm grateful,
my lord. Today, my lord, your lordship cannot pass any order in this appeal because.
Go to the Supreme Court then.
My lord, what I'm
you are
saying.
Not doing good to your client's case, sir.
My lord, kindly see my lord's last order.
Don't be unreasonable. Give them a copy.
My lord, I will certainly give them a copy.
When?
My lord, I have applied for certified copy.
We don't need certified copy.
My lord, I then by today itself.
Yes, give it.
My lord, kindly
give it. We'll dispose of the appeal. We are not entertaining the appeal, sir.
Under wrong cost title.
We are not entertaining the appeal. Under whichever cost title. But you give him a copy of that.
Itself.
Yes.
My lord,
the appellant has
left open, my lord.
Everything left open. The appellant has come up.
Lordship, kindly don't dismiss it, my lord. Lordship, kindly dispose it.
Being aggrieved by continuation of the execution proceedings without the appellant being supplied a copy of the amended cost title of the
execution petition.
Execution petition.
EC 171 of 2000.
Paragraph. We understand that an order has been passed by the learned single judge in the executing court on June 30, 2025, directing the plaintiffs, plaintiff or plaintiffs?
I'm the plaintiff.
Plaintiff decree holder.
Decree holder.
Plaintiff oblique decree holder to supply a copy of the amended execution petition to the present appellant. Stop. Paragraph. In any event, we do not see how this appeal is maintainable. Stop. However, since the learned single judge has already passed a direction, we do not deem it necessary to pass any order on this appeal. Paragraph. The appeal being such and such stands disposed of along with আছে কিছু application আছে?
Yes, my lord, stay petition is.
Along with the connected application.
Grateful to your lord.
Paragraph, we clarify that we have not
Entered into the merit of the case.
we have not addressed the merits of the case at all.
Grateful to you, lord.
My lord, just one submission, my lord. This appeal is filed under wrong cause title. Just
Paragraph তার আগে লেখো
respondent number 1 has been struck off in.
We are recording your submission. Learned advocate for the respondent oblique plaintiff says that this appeal.
Respondent number 2. Respondent number 2 here in this appeal.
Respondent oblique plaintiff says that this appeal has been filed with wrong cause title.
Grateful to you. Extremely grateful.
এটা দিয়ে তারপরে কি লিখবে তারপরে be that as it may, we are told যেটা আছে না learned judge has passed an order. আচ্ছা তাহলে এই ইভেন্টের আগে দিয়ে দাও এটা ঢুকিয়ে দাও
Grateful to you. ওই অ্যাপেলেন্ট প্রতীক কুমার ভট্টাচার্য কস্ট টাইটেল যা আছে ইন পার্সন।
Interim Order, whole matter, item number 3.
My lord.
Court is ready. Yes, my lord.
I'm appealing for the respondent number 2, my lord. Kindly pardon me, I'm in the virtual mode.
Well, LMJ, he's appearing for LMJ.
Circulate the report.
Yes, so I have to see.
We will also go through the report once.
Your counsel.
Of course, the last order was 26 June 2025, when 2 weeks extra, when 2 weeks time extension was needed to file.
Within 2 weeks.
Yes, yes. No. It is within 2 weeks. That's not. But it said that the order will not prevent learned special officer
from taking
step. Well, nothing has. Well,
you go through the order report.
Yes, yes.
Report file. Report filed by learned special officer in court today be kept with the records. Paragraph. Let copies of the report. Both. Let copies of the report have been made available to learned advocates for the parties who seek a little time to consider the same and come back. How long you need, Mr. Bose?
My lord, this is not a report as such. This is a list of dates.
No. My lord has asked to give the dates also.
Why
give me a week's time, lordship. Give me a week's time.
That what has so.
Otherwise, lordship will not be able to. All the minutes were annexed here.
Well, this is described as a report. Go through it. If there's deficiency, point out the next day.
No, that's what I'm saying, my lord. Yes. Page 50. If you end of the report.
50.
Yes, it starts from page 1. It's all list of dates.
Yes, but against the dates, he has mentioned what has been done on that date. That has been mentioned. Meeting was held wherein special officer apprised the council, etc., etc. So this is what he says. He says this is what he has done.
Very well. Because the
get with the records. What next Thursday, Mr. Chatterjee? Ms. Ghosh or Ms. Chatterjee? Ms.
Yes.
Ghosh, what do we say?
Yes, my lord. Can you keep it next Thursday? Next Thursday.
And Ghosh is fine.
Fine.
That's what how she's described. Describes herself.
July 17.
Yes.
Item number 4.
Milord, I'm praying for a very short passover, Milord. Mr. Shobhapri Mukherjee is on legs before court number 39, Milord. I'm for the appellant, Milord. Short passover, Milord.
order item number 5.
হ্যাঁ আসুন স্যার। Yes, Mr. Kushal.
Milad, where I stopped yesterday, Milad, I was placing page 100 of Milad, the first.
Yes.
The first volume of the state petition, Milad. Today is Guru Purnima, Milad. This is, Milad, the work order that was, Milad, I was relying upon. I had placed half of it, Milad, but I would again, Milad, start from the beginning, Milad. It is dated 28th of November 2013, where Milad, Steel Authority of India, Milad, writes to Vizag Seaport Limited, handling of sale coking, non-coking coal vessel at your terminal. We are pleased to issue this work order to you for handling our coking coal vessels at your terminal for a period of 6 months with effect from 14/11/2013, extendable by a further period of 3 months at sales option. This work order supersedes all previous letters exchanged between SAIL and VSPL. In this matter, shall be the sole repository of the terms and conditions of this work order. The above shall be subjected to the following. First is the rate. The consolidated rate payable to VSPL shall be 166.5 for the entire operation, including documentation up to wagon loading. No escalation shall be payable by SAIL during the period of the contract, including extension period. So, Lordship will recollect, my lord, yesterday when I was submitting, my lord, there were 3 different slabs how the integrated terminal service charges are to be, my lord, governed, my lord. 167 for a minimum guarantee cargo, my lord, less than that 0.75. If it falls, my lord, that's 119, my lord, and if it falls further below, it's 97. And if there's an escalation beyond, my lord, 3 million metric tons per annum, 167 plus for the escalated excess to 3 million, my lord, and 97 per metric ton, my lord. That was the calculation. Now that, my lord, has been given a go by, and this is a universal 166.5 is a universal, whatever may be the cargo, notwithstanding it should always be the minimum guaranteed cargo which the SAIL is supposed to provide in the berth for the claimant to, my lord, or the appellant herein, my lord, to, my lord, disperse, my lord. Now, Lordship will kindly see the penalty, committed discharge rate and penalty, the second clause. The committed discharge rate shall be 22,000 metric ton. Earlier it was, Lordship will recollect, it was 60,000 plus 30,000, my lord. Now they say it's 22,000 metric ton for all hatch lightning and 15,000 metric ton per day for full discharge or selective hatches, full discharge, my lord. Now, penalty part, my lord, Lordship, I was on the last occasion, yesterday, my lord, when I was submitting, it was 30,000 US dollars pro rata per day or 20,000 US dollars pro rata per day. There were two different slabs with the chart annexed as annexure 1, which I was, my lord, relying upon, my lord. Here the penalty has changed now, my lord. It is US dollars 12,500 per day or pro rata shall be applicable in case of any shortfall in discharge rate. The penalty shall be recoverable from VSBL from time to time. Now again, berthing priority and lay time, my lord. The same, more or less the similar clause with the ousting priority of sail vessels, my lord. VSPL shall provide ousting priority and at EQ8 berth for Steel Authority of India vessels. SAIL shall endeavor to give 36 hours notice to VSBL. Notice, Lordship would recollect, my lord, in the earlier clause in the short-term agreement, my lord, there was a 30 days window for giving a prior notice for the movement of the vessel to the berth, so the berth should not get congested, my lord, and there will be a, the cargo should be streamlined and the process should be seamless. That was the essence of the contract throughout, my lord. So that has been reiterated here again, my lord. SAIL shall endeavor to give 36 hours notice. Here the notice period also has changed, because in case it is, my lord, high volume of cargo, my lord, notice has to be given in a shorter period of time, my lord, enabling, my lord, VSPL to, my lord, maneuver its machineries for unloading of the cargo, my lord. In case any vessel other than sales vessel, my lord, this clause remains the same as earlier, my lord, the ousting priority part, my lord. Now, last line of this paragraph, the second, my lord, paragraph is important, my lord. Time shall start counting immediately after completion of draft survey. So time and again, my lord, since the beginning till the dispute, my lord, started, my lord, it was always a time-bound contract. Nowhere it has been, my lord, envisaged by either parties that the contract was not time-bound, my lord, because everything depended on, my lord, how the cargo will move in and how fast the cargo will be taken out from the port premises, my lord. This was the whole arrangement, my lord. That will now take the next line, my lord. In case VSBL fails to berth the vessel on account of berth being preoccupied with non-sail vessel, time will start counting from the completion of lighterage at outer harbor from the time of arrival, as the case may be. VSBL shall also provide preferential berthing at berth EQ9 as and when required. That was the additional berth, my lord. When I started my submission yesterday, my lord, there were two berths I mentioned. One is EQ8, which is the primary berth, and there's a secondary, which is EQ9, which has been mentioned specifically. If EQ8 is congested, EQ9 can be used, and it is on VSPL to organize that berth for, my lord, discharge of the cargo, my lord. My lord, I will not, my lord, place this document any further, my lord. Aditya, এটা আর payment terms টা দেখাও। My lord, will come to, my lord, page 103 once, my lord. Paragraph 8, my lord, payment terms.
Used to state the statement of facts when the payment comes from the book. Right.
Yes.
468. 71. Volume 4 টা ready রাখুন।
Yes, go ahead.
Milord, Lordship will kindly take paragraph 8, Milord. That's the payment terms. The payment shall be made for 99% maximum of draft survey quantity. Payment shall be made as per the breakup given below. 75% of ITSC shall be paid within 7 working days after completion of discharge and raising of invoice by VSPL. Balance 25% of ITSC shall be paid within 7 working days after completion of dispatches and raising of invoices. Then, Milord, VSPL shall submit the following documents. The invoices that I am not, Milord, placing before your Lordship, Milord. The scope of services I will skip through, Milord. Lordship will kindly see now paragraph point number 11, Milord. I'm not, Milord, again placing the liability part of VSPL, which is almost similar to the short-term agreement. What were the liabilities of VSPL vis-a-vis the liability of, Milord, the Steel Authority of India, Milord. Statutory obligations, Milord, I would like to, Milord, place some emphasis on this, Milord. That is at paragraph 11, Milord. VSPL shall be wholly liable for due compliance of all applicable statutory provisions and be responsible for all such obligations arising thereunder for the terminal operations, including environmental laws, labor laws, especially Minimum Wages Act, ESI, contract labor, etc. VSPL undertakes to indemnify SAIL for any obligation arising out of the above. Now, Milord, pausing here for a moment, Milord. Lordship, when I was referring to Annexure 1 yesterday, Milord, there was a chart where there was a breakup, Milord, where royalty aspect was mentioned and TAMP regulation will be applicable. Now, here, my lord, drawing an analogy, my lord, which was actually in turn, my lord, when the learned tribunal was deciding this aspect, whether there is any applicability of the tariff authority of major port under section 60 of the old act, my lord, it was considered that statutory provisions, compliances and all would include the statutory provisions as has been, my lord, enumerated in the Major Port Trust Act. So, my lord, this in not in so many terms have been mentioned, but parties by their conduct had adhered to the same, my lord. And that would reflect when I will place the award hereafter, my lord. I will be probably able to demonstrate, my lord, how the learned tribunal had arrived at a finding that yes, TAMP is a necessary part of the contract. It stands at an independent limb, not dependent on the contract. Rather, it is in addition to the contract and not in derogation to thereto, my lord. That is the one aspect, my lord. May I, my lord, now take your lordship, my lord, to volume 4, the award, my lord. Page 470, my lord. It's a majority award which I will place, which is in our favor, my lord. 478, I'm sorry, my lord. কোনখান থেকে দেখাবো বলতো দীপ্ত কোনখান থেকে প্যারাগ্রাফ 4 থেকে হ্যাঁ প্যারাগ্রাফ 4 থেকে Lordship will kindly straight away, my lord, come to paragraph 4 of the award, my lord, at page 482, my lord. In this paragraph, my lord, and just the real crux of the dispute has been explained by the tribunal, and may I place this, my lord. The present dispute arose from storing of cargo beyond the specific limit after free period as stipulated in clause 5.12. Yesterday, my lord, when I was, my lord, making my submissions, my lord, my opening submissions, my lord, I made certain reiteration with regard to, my lord, clause 5.12 and how the clause 5.12 forms the basis or the fulcrum of this entire short-term agreement, which Millard had not been adhered to, Millard, which gave rise to a dispute, culminating into this entire series of proceedings, Millard. The claimant was under an obligation to store maximum cargo up to 60 metric tons, which was the first part, Lordship, 60,000 metric tons, which was the first part of Millard, the clause 5.12. And in case of exigency of the claimant was obliged to store a further 30,000 metric tons for a period not exceeding 15 days, provided the respondent issues a 30 days notice of their need to store higher volume of cargo. The port area is in fact a stacking area as opposed to a storing area. And as such, it is mandated that the cargo is to be evacuated quickly in order to accommodate other cargo from other vessels and thereby to avert the payment of demurrage. Now, here, pausing here for a moment, demurrage, the term has not specifically mentioned in the agreement, but the penalty has been specifically mentioned, and essence of the demurrage is that, again, when I was making my submissions, Millard, demurrage has to be calculated in the manner as stipulated under section 60 of the Major Port Trust Act, and the scale of rates as provided by TAMP, Millard, that would be squarely applicable, Millard. Thereafter, Millard, this is why the penal charges are prescribed either by statute or by agreement if the cargo is stacked beyond normal period. In terms of the agreement, the discharging of cargo round the clock and committed discharge rate as defined in clause 2.0 of the short-term agreement with the provision of penalty as are also described therein. The claim of the claimant is supported by the orders of TAMP. In the instant preceding the dispute between the parties started happening intermittently from 16th of May 2009, and the claimant put the respondent on notice that they should evacuate the cargo by improving the wreck movement. The claimant also informed the respondent that 2 wrecks per day as contemplated in this STA were not being allotted, for which the cargo was being overstacked, but the respondent did not pay any heed to the notice issued by the claimant, and ultimately on 2012-2010, the claimant put respondent on notice that they are making a demurrage claim for cargo stacking over 60,000 million metric tons as per TAMP rate under the provisions of Major Port Trust Act. But the respondent did not reply. Thereafter, notice of arbitration, Millard. The denial of the respondent, Millard, is recorded in paragraph 5, Millard. The respondent denied all the allegations and claims of VSPL by filing a statement of defense, and it is inter alia stated that the claim is barred by limitation. That was a preliminary point. When the issues were framed, Millard, this was a preliminary issue that was framed and was answered in negative in favor of the respondent, Millard. And the claim is also barred under the provisions of the Major Port Trust Act. The claim again violates the guidelines of the Tariff Authority of Major Port. During the STA period, the claimant had claimed integrated terminal service charges as per the STA, but has never raised any such demurrage bill for cargo while claiming final payment for each vessel, and as such the claim for payment of demurrage is not payable. As per the STA, the respondent offered a consolidated rate of 167 per metric ton for all services to be provided to it. The said consolidated rate includes provision for lease rental for the space provided exclusively for storage of materials to be imported by the respondent. The payment terms mentioned in the STA cannot be compared with or equated to the various scales of rate mentioned by the claimant in its purported agreement with VPT. Hence, the question of levying or paying demurrage charges applicable for transit space does not and cannot apply to the respondent for using leased area earmarked in the STA. The said charges, if at all applicable, are for using transit area, and they do not pertain to the exclusive area earmarked as leased area for the respondent as per the STA. In the TAMP notification, number such and such dated 15th of April 2009 is mentioned thus. VSPL in our advice introduced conditions stipulated in clause 4.6 of the tariff guidelines stating that if operational area is leased out on rental to the user, demurrage of cargo stored therein shall not be levied again. Under the long-term agreement, it was the responsibility of the claimant for evacuation of the cargo. The payment terms as per STA are different from Appendix 6 of the license agreement, which deals with charges payable to Vizag Port. Even the TAMP notification dated 15th of March 2005 was not in force when LTA was signed between the parties. The respondent by its letter asked the claimant to provide the breakup of rates to understand the impact of various components contained therein in order to remove any ambiguity. However, the claimant did not provide for any such breakup and just combined all components together. Since the rate included component of lease rental, if any, and of cargo to be handled by VSPL berth, no further payment was required to be made as per the order and policy guidelines of TAMP. Millard, then I will, Millard, skip a few paragraphs, Millard. I'm sorry, Millard.
So one.
I'm sorry. I know. Paragraph 12 to that.
Yes.
I believe, Millard, I will take the rest of the day, Millard.
Rest of the day?
Yes. Because I need to place this, Millard, then I will go to the impugned order, Millard.
Then please try to conclude today. You take the rest of the day.
I will take one more day. Why I tell your lordship, Millard, I will place the award. This award needs to be placed. Also the minority award, Millard, and where, Millard, the setting aside court, Millard, had, according to us, Millard, probably has.
We'll only request you to be as concise as possible.
I will try and there I will cite only 3 Millard authorities.
If necessary, what we always request learned counsel is to keep the oral submission as short as possible.
I will try and do
file
so,
a
Millard.
written note if
That
necessary.
we will do, Millard. That we will
But
do.
then
Millard.
release করে দাও তাহলে।
Better release for the day.
Yes.
I'm sorry, Millard, but this needs to, Millard, because I'm trying to, Millard.
The problem is that our time is limited.
I know, Millard. I understand.
So many
Millard.
cases to attend to.
I'm sorry, Millard.
Try to finish it and file written note.
I will do so, Millard. I will do so, Millard. Because Mr. Ghosh has to, Millard, also reply to me.
No, of course, that is why. You see, so please don't take in another day.
Okay.
Try to.
I will try. That is why, Millard. I will try and do so, Millard.
No dispute between the parties at all. They have paid everything except the fact that they are claiming demurrage. All these things are totally not, I should say, not relevant for the purpose. Only thing under clause 5.12, they are claiming damage.
That is the shortest point. I would join issues with Mr. Ghosh here, and that is the shortest point, Millard, and that has been dealt with, Millard.
All that. You don't want to accept the damage. I should be only on very narrow scope.
Now, Millard, paragraph 11, Millard, integrated terminal service charges. This is a recording, Millard, of the tribunal, is a consolidated rate payable to the claimant, which includes service charges for the goods to be stored at the leased area earmarked for the respondent in the form of lease rental. The issue of transit use stroke demurrage is not considered or covered either under LTA or in the STA because the area as provided to the respondent was on lease rental. In terms of the STA, the respondents, apart from paying ITSC at the rate of 167 rupees per metric ton, is not liable to pay any other amount. In fact, the TAMP has laid down that once a licensee collect the lease rental in respect of a particular land in question, the said licensee cannot charge from its lessee any demurrage on cargo stored therein, as ITSC covers all charges payable. In this case, ITSC at the rate 167 per metric ton is inclusive of lease rental, which was being charged by the claimant to the respondent. TAM guidelines were accepted by the claimant without any protest and are still in vogue. Now, Millard, here, Millard, when the respondent, Millard, canvassed their, Millard, case before the tribunal, on one hand, they say that TAMP is applicable, and on the other hand, they say TAMP is not applicable. So, Millard, the learned tribunal, Millard, while Millard proceeding after framing of the issues and proceeding on the materials available before the tribunal, Millard, had, Millard, dealt with how 5.12, the clause, is applicable to the current dispute and how demurrage is applicable in terms of the particular clause, Millard. I will come to that in a short while, Millard. Millard. Again, para 12, Millard, clause 5.12 of this STA mentioned only about the quantity of cargo to be handled and stored and not for any other interpretation as alleged by the claimant, Millard. All these were the submissions, Millard. I will quickly skip through, Millard, and I will come straight away to the issues at paragraph 15, Millard. What are the issues that were framed? There were 10 issues that were framed, Millard. One is whether the proceedings are maintainable, Millard. The second is whether the claim is barred by limitation. That was the second issue, Millard. Whether the arbitration proceeding are barred under the regulation framed by the TAMP. 4, whether the respondent has committed breach of contract as alleged. 5 is whether claimant has committed breach. 6, whether it is a case of lease and the claimant having collected the lease amount is not entitled to any demurrage, Millard. 7 is whether the integrated terminal service charge is being levied, including storage charges also. 8, whether the claimant is entitled to any amount and interest and so on and so forth, Millard. Millard, in detail, Millard, from paragraph 16 onwards, Millard, all these clauses, Millard, and there are certain documents, letters, they're all being, Millard, dealt with, Millard, and the submissions were recorded, Millard. I will, Millard, since your lordship has, Millard, expressed your lordship's mind, Millard, I will quickly skip through this, Millard, and lordship, I will take your lordship straight away, Millard, to the findings, Millard. I will not, Millard, trouble your lordship with the details of the submissions made by the councils, Millard, and I will straight away, Millard, take your lordship to the findings. Findings. I'm sorry.
You can place page 490. That summarizes the claimant's case and the respondent's case.
Yes, Millard. That is para 30. I believe, my lord.
31.
31, I'm sorry, my lord. A case of the claimant VSPL. I'm so grateful, my lord. Thank you. VSPL took lease from VPT a certain portion of Vizag port area and thereby stepped into the shoes of VPT to realize storing, demurrage, etc. charges from the importers, exporters. VSPL then entered into a short-term agreement with SAIL. VPT comes within the purview of Major Port Trust Act, which authorizes the TAMP to fix the scale of rates, etc., including demurrage, for keeping the cargo by the user beyond free period. Thus, VSPL charged demurrage storage charge from SAIL for violating clause 5.12 of STA, keeping their cargo beyond free period. The respondent's case has also been summarized, my lord, from paragraph 35, my lord. In terms of STA, VSPL earmarked the port area for sale and they are paying lease rental therefore. STA and its ITSC is a self-contained agreement for which TAMP has no role to play in the instant case. Moreover, VSPL consciously deleted the term demurrage and transit area while settling the rates with TAMP. Conduct of VSPL is self-contradictory. For example, once they charge demurrage on the dates and then on the same dates they give incentive to SAIL for reducing the rates. Once they requested SAIL not to divert the vessel and then showing storage of excess cargo on the same dates and charged demurrage. Once they sat in review meeting without raising any issue of demurrage, but charged the same. Millard, issue number 1, Millard, I will come at page 41, Millard, paragraph 41, Millard. This is a very vital, Millard, document, Millard. The Steel Authority of India filed a section 16 saying that this contract cannot be, it's not an arbitrable contract because the tribunal perhaps cannot adjudicate on this. I will cite that order, my lord. Order type page ta bolta ekbar. I will just take a minute. Yes. Yeah, yes. What the contention of the respondent was that it was a private agreement, and I'm sorry, I will just hand over, my lord, the copies, my lord. I'm going to order it again, Ashona. Not a part of this. It's not a part of the paper book, my lord. That's why I've handed over an additional copy, my lord. But will kindly take, my lord, see, my lord. I will take your lordship straight away to page 3, my lord, of the order, my lord.
Yes.
In the present second paragraph, my lord. In the present application under section 16 of the Act, amongst other prayers, it is specifically mentioned in paragraph 28A, an order to be passed rejecting the reference made by the claimant on the ground that the tribunal is not a proper forum to adjudicate. We, the tribunal, however, of the view that as the claim of the claimant is based on breach of contract as mentioned in the original petition, before this tribunal, question of breach of contract cannot be decided by TAMP. Therefore, the tribunal has jurisdiction to entertain the claims based on breach of contract. Hence, the application stands rejected. Now, to come up for respondent to file the statement of defense in counterclaim, etc., my lord. So they initially, my lord, said that it has to be decided by TAMP. And the court held TAMP cannot decide this aspect.
Not the court.
The tribunal, I'm sorry, my lord. But under the new act, the court and tribunal is almost pari materia, my lord. So,
fortunately not. Not yet.
Not yet, but let's see.
Yes.
So the tribunal held, my lord, that TAMP cannot decide this aspect. The tribunal has jurisdiction because it's a breach of contract of the clause specifically mentioned therein, my lord. So, my lord, this issue, my lord, was, my lord, taken up, my lord, at paragraph 46 of, my lord, the award, my lord. May I, my lord? Paragraph 40. May I, my lord? In order to appreciate the claim of VSPL, the interpretation of clause 5.12 of the STA is to be understood in its proper perspective, and we quote the said 5.12 of the STA, which is read as below. Storage and stacking. VSPL shall ensure storing of the cargo grade-wise up to a maximum of 4 grades and up to a maximum cargo volume of 60,000 metric tons. VSPL shall, in case of exigencies, endeavor to accommodate cargo for of a further 30,000 metric tons for a period not exceeding 15 continuous days. However, SAIL shall give 30 days notice to VSPL to organize stacking requirements of such higher cargo volumes. If the cargo commitment by SAIL to VSPL is expected to go beyond 2 million metric tons per year, VSPL shall organize for storage of cargo up to 90,000 metric tons with a further provisions of 30,000 metric tons of coal in exigencies for a period not exceeding 15 days, etc. Now, para 47, on a plain reading of the clause, it clearly appears that it is divided into two parts. The first part contains the main case of the claimant, and the second part is the second part in the last sentence is applicable, where cargo commitment of SAIL to VSPL is expected to go beyond 2 million metric tons per year. Now, the main claim of VSPL stands where the cargo volume of VSPL at the port area, which was allegedly taken on lease by VSPL from VPT, exceeds 60,000. The VSPL shall, in case of exigency, endeavor to accommodate cargo for a further 30,000 for a period not exceeding 15 continuous days, emphasis added. Again, on a plain reading of the said clause, it appears to us that the endeavor of VSPL to accommodate a further quantity of 30,000 metric tons over and above 60,000 metric tons is undertaken, and for that, SAIL is to give a 30-day prior notice to VSPL to organize stacking requirement for such higher cargo volume of 30,000 metric tons. This condition is interpreted by the respondent altogether in a different way. It is the argument of the respondent that the condition of notice as stipulated in clause 5.12 of the STA is only for the purpose of organizing stacking requirement. It is also argued by them that the clause is conspicuously silent as regards what happens if such notice is not given by the respondent. Therefore, according to the respondent, the VSPL is by contract obliged to accommodate the cargo of SAIL up to 60,000 metric tons plus 30,000 metric tons, that is 90,000 metric tons at the port area. It is the further argument of the respondent that since clause 5.12 is silent as regard what happens if no notice is given, it has got no implication as regards issuance of any notice by the respondent. Now, let paragraph 50. It is admitted by the Steel Authority of India in its written argument that the major bone of contention between the parties lies in the interpretation of clause 5.12 of the short-term agreement, and they interpreted the said clause as follows. In case of stacking of 60,000 metric tons, then an additional 30,000 metric tons could be accommodated for a period not exceeding 15 continuous days. Therefore, the storage of 90,000 60 plus 30 should not exceed for more than 15 continuous days. If the cargo was expected to go beyond 2 million metric tons per year, then VSPL has to organize storage of cargo to 90,000 metric tons of coal for a period not exceeding 50 days. It is also stated there, in this second situation, there is no requirement to give notice to VSPL, and it was for VSPL to organize storage up to 90,000 metric tons plus 30,000 metric tons. In other words, the total storage stacking was for 1,20,000 metric tons for a period not exceeding 15 days. Thus, in the above, the respondent has not mentioned anything about their obligation to give notice in case of storage of excess cargo. If the above argument is to be accepted, that would be an oversimplification of the whole matter. Then we are to accept that VSPL was to store 90,000 metric tons of cargo of Steel Authority of India Limited for all the time during the contractual period. Then provision for notice as contemplated in clause 5.12 becomes an OCA. Then there remains no questions for free period as contemplated in TAMP orders. Then the port area becomes a warehouse. On a plain reading of clause 5.12 of the STA as quoted by us above, it would be clear that the same consists of two distinct parts, which is also admitted by all. And in two parts, the provisions for free period of 15 days has been separately mentioned. And in case of the first part, it is specifically mentioned the provision for a 30-day notice. The first part of clause 5.12 of the STA again consists of three sentences. The first sentences say that VSPL is obliged to store up to a maximum. I'm putting some emphasis on this finding of the tribunal, because this is where my entire claim lies. The entire crux of my claim germinates out of this finding of the tribunal, which was exactly our case. May I read again, The first part of clause 5.12 of the STA again consists of three sentences. The first sentence says that the VSPL is obliged to store a maximum cargo volume of 60,000 metric tons. The second sentence starts, there the VSPL is obliged to accommodate cargo of a further 30,000 metric tons in case of exigencies, which has been underlined, for a period not exceeding 15 continuous days, that is the free period. Then the third sentence starts with the word however, and makes SAIL obliged to give a 30 days prior notice to VSPL for such higher cargo volumes. Lots will kindly see that higher cargo volumes has been made in bold. So the tribunal, in their wisdom, my lord, had, my lord, divided the clause into three parts. The first part of the clause into three parts. First is our committed rate of, my lord, discharge, that is 60,000. In case of exigencies, an additional 30,000 with continuous 15 days of free period, my lord. And for that 30,000, a 30 days prior notice becomes mandatory. So this is how, my lord, the tribunal has come to an understanding of the clause, of the first part of the clause, my lord. My lord, thereafter, my lord, goes on to say, my lord, thus it is clear that the maximum volume of cargo of the VSPL is obliged to store, maximum volume is 60,000 and no more, and the higher volume of 30,000 of cargo only when 30 days notice is given by sale. When the maximum volume of 60,000 metric ton continuously exceeds for more than 15 days, the sense of using the word however at the beginning of the third sentence connects it almost in the same breath with the first two sentences of clause 5.12 of the STA. In the said clause, the words for a period not exceeding are very significant for determination of the dispute between the parties. On perusal of those words, it appears that even in that case of 30 days notice, VSPL was obliged to arrange storing of 30,000 metric tons not exceeding 15 continuous days. So, my lord, pausing here for a moment, my lord, my minimum assured guaranteed discharge would be 60,000, not more than that. In case of exigency, additional 30,000. Only when a notice comes. So that notice, my lord, never came. But excess cargo came in, my lord. So that is the, my lord, the balance of the excess cargo balance gave rise to, my lord, stacking of cargo, which, my lord, entailed us to, my lord, ask for demurrages. Because, my lord, I have been, my lord, covered under, I am within a port premises. All the regulations with regard to port, the scale of rates, my lord, everything is squarely applicable to me. I'm operating within a premises, a restricted premises, my lord. So I have to adhere to everything that is applicable statutorily within that premises, my lord. My lord, then, my lord, with lordship will kindly see, my lord, when the sense of using, I have just very say, my lord, I will take your lordship to page 494, my lord. In the same, I'm reading, my lord. In এটা প্যারা 54টাই আমি পড়ছি স্যার, এই sense of the word is possible. In the said clause, the words for a period not exceeding are very significant for determination of the dispute between the parties. On perusal of those words, it appears that even in that case of 30 days notice, VSPL was obliged to arrange storing 30,000 metric tons not exceeding 15 continuous days. That means the right of extra storage of cargo on notice is not unlimited for sale. So even if they give us a notice, they cannot give us more than 30,000 within that free period, my lord. They cannot, my lord. That is absolutely, my lord, abundantly clear, my lord. It is again not that sale would give notice every 15 days for excess storing of 30,000 metric tons, and VSPL would be obliged to store the same. It is clearly mentioned in clause 5.12 that the right of sale was given in case of exigencies and only exigencies. It has been specifically clarified, my lord, with no unambiguous terms, my lord. And my lord, even when we are reading a contract, my lord, understanding the clauses of the contract, my lord, we have to take it on the literal interpretation, what is spelled out clearly in the contract, my lord. We cannot apply the mischief rule by saying that since it is sub silentio, it could have a different meaning or a different trajectory of meaning of a particular clause. We have to interpret the clause like we need to have to interpret the paragraphs of the judgment in its literal and plain simple interpretation, straight way of interpreting. If it does not make a sense, then we have to go to the other. That is what I understand, my lord. So the principles are more or less same, my lord. And this clause is unambiguous and absolutely abundantly clear, my lord. Lordship will now take the next paragraph, my lord. It is a pointer to note that for the second part of clause 5.12, there is no whisper of notice. Although there is also a free period of 15 days, because the first part is for a day-to-day clearance of cargo, keeping the cardinal principle of MPT Act that the port area is not to be used as a warehouse, but to be used as transit area. The second part of the clause deals with the cargo volume on per year cargo commitment basis. So there's a distinction that the tribunal has drawn. Also from a reading of the clause, it has been abundantly clear, my lord. The first part is for a day-to-day. The second part is the annual volume of cargo. The annual volume, again, Lordship would earlier recollect, my lord, it has been mentioned not to go beyond 1.5 million metric tons, maximum up to 3 million metric tons per annum. And there was a rate chart that was, which was appended as annexure 1 to the short-term agreement, my lord, which I, my lord, spelt on the last occasion, my lord. VSPL would keep itself ready to accommodate 90,000 plus 30,000 metric tons in exigencies for a period not exceeding 15 days. And this is when cargo commitment by sale to VSPL is expected to go beyond 2 million metric tons per year. Again, my lord, I just now, my lord, submitted that 1.5 is the max cap that can be, my lord, achieved per annum, which can go up to 3 million. But when it goes beyond 2 million, it's 90,000 plus 30,000 in case of exigencies for a clear period of not exceeding the free period of 15 days. I have to do it, my lord. That is my obligation, my lord. In the instant case, VSPL claimed a demurrage. Now the real, my lord, part of the claim of ours, my lord. In the instant case, VSPL claimed demurrage storage charges on the basis of the first part of clause 5.12 of STA. I am not absolutely, my claim is not based on the entire clause 5.12, but the first part of 5.12, my lord. In view of all above, our mind leans to accept the interpretation of the clause that when the volume of cargo exceeds 60,000 continuously for a period of 15 days without any 30 days notice from sale, the VSPL is entitled to claim demurrage storage charges in terms of the TAMP orders. That is the mind that was expressed by the learned tribunal, my lord. We shall now discuss as to whether MPT Act and also the TAMP orders are applicable to the instant case or not herein below. A serious debate was made by both parties as regards the application of MPT Act, so also the orders of the TAMP authority in the instant case. Let us examine the matter cautiously. There is no denying of the fact that the transaction between the parties were made on the land of the port. The users of the land of seaport are statutorily regulated by the Major Port Trust Act 1963. In the footnotes of the STA itself, 3 letters bearing reference number 127001576 and 5802007-08 dated 14th November 2007, and the next one is 27th December 2007, and the third one is 30th January 2008, find mention to be forming a part of the integral part of the STA. Thus, in Exhibit C16 and C17 at page number 82 and 84, in point number 6 and 7, VSPL accepted the proposal of sale for priority as per berthing policy and procedures followed by VPT. Again, Exhibit C20 at page 132 and in paragraph 4 of the said letter at page 133, it is clearly mentioned that with regard to sales apprehension on ousting priority for sale vessels, it was confirmed by VSPL as port under meaning of MPT Act 1963, Section 42, that VSPL is fully authorized to give such ousting priority to a valued customer like sale. VPT came within the purview of the Act of 1963 by Amendment Act of 1974. Then again, Clause 1K of the STA has it that the VSPL shall make different types of facilities in order to take care of urgent need of sale, including congestion at port, at the berthing policy and procedure followed by Vizag Port Trust. There is no denying of the said fact that VPT comes within the purview of the Act of 1963. Even the definition clause 2 of the STA, the MPT is defined as the Major Port Trusts Act 1963 as amended, supplemented, reenacted, or replaced from time to time. Naturally, the question comes in our mind, if there is no scope of application of MPT Act in the agreement, what was the purpose of defining the MPT Act in clause 2 of the STA? Question mark. In our view, the answer lies in the affirmative. All these questions as to whether the MPT Act will be applicable in the instant case are answered in STA itself in clause 5.5. Lordship, I placed the clause earlier, my lord, and that clause has been reiterated here. My lord, may I place it, my lord, again? Clause 5.5 of STA deals with the provisions of discharge of cargo, and the second paragraph of the said clause reads as under: discharge of cargo shall be round the clock in terms of this agreement and as per rules and regulations that are enforced by VPT stroke MPT Act from time to time, emphasis added. The main transaction between the parties centers around the discharge of cargo, and clause 5.5 has clearly mentioned that the same will be regulated by the rules and regulations that are enforced by VPT stroke MPT Act from time to time. Thus, the argument of the respondent that the STA, which is a self-contained agreement, does not give any scope to import the application of MPT Act does not cut any ice. Then, again, clause 5.28 of the STA recognizes the authority of VPT in the unlikely event of non-performance stroke underperformance of the berth. The authority of VPT is again recognized in clause 5.34 in respect of berth discharge at nominated area stroke other place nominated by VPT, and in that case with the assistance of VSPL, the sale is to take clearance from the VPT. Again in annexure 1 to STA, where the chart, Lordship, I was referring to this, Millard, yesterday and today also, Millard, the chart of ITSC of rupees 167 and its various components are described. It is clearly mentioned in respect of royalty and lease rental that the same will be in terms of VPT stroke TAMP notification. All these are what are stated and provided and also contained in the STA itself as regards the application of MPT, so also the application of TAMP authority. Furthermore, the respondent sale itself tried to build up its case on the notification of the TAMP authority. It was argued before us that in terms of item number Roman 22 at page C/109, the term transit area was deleted at the request of the claimant. Our attention was also drawn at clause 21 at page 108 for the respondent, and with these two clauses, he tried to impress upon us that the term transit area there are also taken out by the TAMP authority at the request of the claimant. These two clauses will be discussed by us subsequently at the appropriate place, separately in other context. I'm sorry. But in case those two clauses are in order of the order of the notification of TAMP authority, being notification number G40 dated 31st of March 2005. Thus, the respondent was also required to build up their case with the help of the order of TAMP authority. Moreover, in their written statement of defense and written notes of argument, the respondent had heavily banked upon the TAMP orders to build up their case. 64. TAMP authority is a creation of the Major Port Trust Act under the provision of section 47A of the Act for the purpose of imposition and regulation of scale of rates at the port for services performed by the board and other persons. In order to know the function of the board, the provisions of section 42 clause 3A and 4 of the MPT Act are to be understood. Those clauses are read as under. Without prejudice to the provisions of subsection 3, but only thing is, Millard, I will conclude today, Millard, and Millard, the judgments that I would like to rely upon, Millard, I will give an advance copy to Mr. Ghosh, sir, so that he can deal with them, Millard.
On the next date, before Mr. Ghosh starts, just indicate the relevant paragraphs.
3 judgments, not more, Millard, only relevant paragraph. The scope of
34.
With the latest one.
We'll put you on notice, Mr. Ghoshal. We'll rise at 4:15. I have an administrative meeting at 4:30. Okay. Hey, bole diyo. Watch it.
May I commence, Millard? Grateful. Without prejudice to the provisions of subsection 3, a board may, with the previous approval of the central government, enter into any agreement or other arrangement by way of partnership, joint venture, or any other manner with anybody, corporate or any other person, to perform any of the services and functions assigned to the board under this act on such terms and conditions as may be agreed upon. No person authorized under subsection 3 shall charge or recover for such service any sum in excess of the amount specified by the authority by notification in the official gazette. On plain reading of these clauses, those clauses as stated above, it appears that the board may authorize any person for any of the services mentioned in clause I of section 42 and such terms and conditions as mentioned agreed upon, which were assigned by the board itself by the act. Among those functions, those are assigned to the board are landing, shipping of transshipping passengers and goods between vessels in the port, receiving, removing, shifting, transporting, storing, or delivering goods brought within the board premises, including the carriage by the neighboring railway areas or vice versa, and the like activities find mention in clause 1 of section 42. In the instant case, it is admitted that the claimant took lease of a certain port area, namely EQ8 and EQ9, from VPT for a period of 30 years. And on the basis of that lease agreement, the claimant enter into a long-term agreement with SAIL, and thereafter, as the said LTA could not be given effect to for some technical reasons, like non-performance of dredging of the seaport to the optimal level as stipulated in the LTA, the STA between the parties was executed. Thus, in view of the above, possession of MPT Act, VSPL steps into the shoes of VPT in order to perform the various activities assigned to the board of VPT, and on the strength of that lease agreement, only the VSPL got authority to enter into a short-term agreement with SAIL. So this agreement, my lord, pausing here for a moment, my lord, this agreement is not an independent agreement. This agreement is a fallout of the lease agreement which I had entered upon with VPT, Millard, allowing us to become a lessee of VPT, working inside the port premises and then entering into it's a chain of agreements, Millard. The first agreement, although VPT is not a party to this entire proceeding, Millard, and they shouldn't be, because we have assumed the kind of authority that was derived from the agreement of lease of 30 years. I stepped into the shoes of VPT, gave out on lease the two berths, Millard, EQ8 and EQ9, Millard, and then started collecting the ITSC. And if in case of demurrage, Millard, in case of stacking and storing of excess cargo, Millard, now I will be responsible because I am obstructing the port premises, Millard. So that is the precise purpose why I claimed demurrage, and nothing more and nothing less, Millard. From the facts and circumstances of the documents placed before us by both the parties, we have no reason to disbelieve that this possession was unknown to the SAIL at the time of execution of the STA. In fact, on the request of SAIL, VSPL supplied a copy of such lease agreement to them. Here in the instant case, in our considered view, the SAIL is a user of the port under the STA, and VSPL stands in the possession of the owner as a lessee of VPT. Now, for stacking of the cargo beyond the limit of 60,000 metric tons at the port area, even after free period, VSPL made insufficient supply of railway wrecks responsible. Both the parties have argued on the responsibility of making requisitions for railway wrecks. According to SAIL, it is the responsibility of the claimant to make the requisition for the railway wrecks in terms of STA agreement, which was not denied by the claimant, but at the same time, the provision of clause 4.11 of STA was referred to by the claimant, and it was argued that such indent for wagon shall be placed by them only when the instructions of SAIL on a day-to-day basis is placed before the claimant. In this connection, we may quote the provision of clause 4.10 and 4.11 of the STA, which reads as under dispatch instruction. SAIL shall endeavor to furnish 7 days prior to the commencement of any particular month the rec movement plan for such month at the rate of 2 recs per day. Such rec movement plan shall not exceed loading of more than 5 recs on any day in view of the capacity restrictions of the wagon loader installed. Wagon indent. VSPL shall place the wagon indent forwarding notes with VPT Railways as per instructions of SAIL on a day-to-day basis. Thus, it appears that it is also the responsibility of SAIL that 7 days prior to the commencement of any particular month, it is to furnish the rec movement plan for such month at the rate of 2 recs per day, and it is the responsibility of VSPL to place wagon indent forwarding note to VPT stroke railways as per instruction of SAIL on a day-to-day basis. Actually, it appears from the document and the arguments of the parties that SAIL have got different steel plants in India, in which imported coal is required for the production of steel and iron, and as such, the choice was also with the SAIL to which plant the railway recs are to be diverted. It is the case of the claimant that although they informed the respondent the stacking possession of cargo at the port on day-to-day basis, requesting them to make proper instructions for the indent of the railway recs, no reply was received from SAIL. Authority vide their letters dated number C26 at page 169, C27 at page 170, C28 at page 172, C29 at 174, C30 at page 175, C31 at 176, C34 at 179, C36 and 37 at pages 182, 183, and several other letters. Clause 1.2c of the STA deals with the responsibility of SAIL, and it has arrangement of necessary allotment of recs by the concerned railway headquarters stroke authorities. So there is no scope for the respondent to deny their responsibility in relation to the acquisition of railway wagons and placing the instructions for the indent, therefore, in terms of the STA. From the message of the SAIL to VSPL dated 22/11/2010 appearing at C48 at page 198, it is clear that SAIL admitted their responsibility in respect of allotment of recs. It is stated that in that message, we are continuously taking up the matter with the port railways for allotment of recs. You are also requested liaison with port railways for allotment of minimum 2 recs per day at your terminal to accommodate the cargo of incoming vessels. In the same page, the reply of VSPL is also appearing, wherein it is stated that VSPL were continuously following up for the recs and were loading them through their system in minimum time on placement. It was further stated by them that recs were being diverted to clear the other cargo of SAIL, which were resulting in stakes accumulation at the terminal. All this goes to show that for the accumulation of cargo resulting in exceeding the minimum limit of 60,000 metric ton continuously for 15 days at the port area was due to non-receipt of sufficient rail recs. SAIL, of course, shirked their, or rather it should be shrinked, I believe, their responsibility, shirked their responsibility in this regard. 70 million. In order to determine the question as to whether there was any breach of contract as stipulated in issue number 4, we shall now explore as to whether there was any provision for charging any demurrage on the excess cargo beyond 60,000 metric ton after the free period as mentioned in clause 5.12 of the STA, as was there in the order of the TAMP authority and in other documents. Of course, it is argued on behalf of the respondent that clause 5.12 is conspicuously silent as regards any charge of demurrage, and the said clause does not contain anything as to what happens if the cargo possession exceeds 60,000 metric ton continuously for 15 days. It was also argued on behalf of the respondent It was also argued on behalf of the respondent that the claimant, while dealing with the TAMP authority, deleted the term transit area in respect of the user of port area by sale. It is also argued in this connection that the term demurrage was also deleted while dealing with TAMP authority at the instance of VPCL. Let us see what is the actual position in this regard. Those matters appear at page 108 and 109 in clause 10, Roman 21 and 22 of the TAMP notification dated 31/3/2005. On perusal of clause Roman 21, there appears nothing that the term demurrage was deleted. Rather, the TAMP authority observed when the private operator himself desired to offer competitive rate, there is no justification to increase the proposed rates as suggested by VPT. On perusal of clause Roman 22, it appears that the term transit area has been defined as the area to be notified by the VSPL from time to time while demurrage becomes payable on expiry of free day. So after 15, every single day, if there is an excess cargo, I am entitled to pay demurrage. 2 VPT because I am occupying, so I have to collect it from somebody. It's not my cargo. It was also observed that the VSPL has not modified this definition to explicitly specify transit area. It is also observed notification about the area to be considered as transit area is an administrative matter to be decided by the operator. And in the absence of any specific definition of this term, it is not found necessary to include it in the scale of rates, and hence the same is deleted. Therefore, it cannot be said that on a reading of the said clause that the port area in the instant case is not being used as a transit area. In this connection, the ratio decided in the case of this one case that has been referred, Millard, Trustee of Bombay versus Jai Hind Oil Mill Company, may be recalled, where it was decided that demurrage charges are levied in order to ensure quick clearance of cargo from the harbor, and those charges are fixed in such a way that they would make unprofitable for the importers to use the port premises as a warehouse. In other words, it can be said that the port area cannot be used as a warehouse by any user. It was further argued on behalf of the respondent that the behavior and dealing of the claimant is self-contradictory. The claimant all along insisted on more cargo and ships in the port area, and at the same time, the claimant went on charging the demurrage. In this connection, learned senior advocate has referred to page 177 of the statement of defense vis-a-vis item number 110 at page 279 of C series, page 284 and 285 of R series vis-a-vis page 303 of C series. It is also pointed out by him from page 177 of the SOD that on one hand, the claimant resisted the diversion of MVPX, and on the other, they charged demurrage vide page 212 of the C series. Similarly, he has also referred to page 179 of the statement of defense vis-a-vis item 272 at page 303 of C series, charging demurrage from the respondent. In reply to this argument on behalf of the respondent, on behalf of the respondent, Mr. Such and Such, learned advocate for the claimant, has referred to some of their letters appearing at page 283, 284, and 285 in the list of documents in the R series by the respondent and submitted as minimum guarantee for the cargo was not fulfilled by the respondent. The claimant resisted the diversion of vessels. It appears from the letter of the claimant appearing at page 283 of our series in respect of diversion of vessels to Gangavaram port, that the Gangavaram, okay, it's Gangavaram here. Gangavaram port, that claimant wanted to place it on record that the diversion of the said vessel was in deviation of clause 1.2 A, 4.1, 4.5, and 4.8 of the STA. In other two letters, also the claimant apprehended causing of huge loss for the diversion of other vessels of sale. I'm reading 72. It is the universal, I'm sorry, clause 1.2 of A of STA speaks about the assurance of 1.5 million metric tons of cargo per annum to VSPL berth for a period of 3 years from the date of signing of the agreement or extended period, if any. Other clause as mentioned in the letter also deals with the volume of extended cargo. It is the universal practice of business that the parties involved in such commercial transaction will always look forward for more and more profit, and in doing so, if there appears any violation of agreement inviting penalty stroke demurrage, the same cannot be avoided or denied. It was also argued on behalf of the respondent that in the review meeting as provided in clause 8 of the STA, the claimant never raised the question of payment of demurrage. On the other hand, the claimant accorded incentives to the respondents by lowering the rate from 167 rupees per metric ton as mentioned in the ITSC. It is also argued on behalf of the respondent that such incentives stroke rebates were given by the claimant to the sale because the sale was the biggest customer of the claimant. This was not denied by the claimant. The claimant has drawn our attention to the provision of clause 8 of the STA and tried to impress upon us that the purpose of review was only to assess the actual quantity of cargo that can be made available to VSPL terminal to test operational parameters, after which terms be reviewed jointly. And if required, the terms and conditions would be further revised. Learned advocate for the claimant further argued that the sitting in the review meeting had not exonerated either of the party for the payment of contractual dues, which is again supported by statutory dues fortified by the TAMP order. To our mind, the stand of the claimant in this regard appears to be acceptable. The respondent also wanted us to invoke the principles of waiver. I'm sorry.
আমি কালকে ওই জাজমেন্টে আমি ওটা পড়ে ব্যাখ্যার উপর দিয়েছি ছোট্ট এক বছর আমরা অন্য একটা ম্যাটারের জন্য লিখছি আমি দিয়ে দেবো SLP লিখেছি দুই লিখেছি slowly যাচ্ছে তো this is the transfer clause আমার ক্লেমটা সার্ভিস করে দিন
Yes. শোনো Yes.
The respondent also wanted us to invoke the principles of waiver against the claimant, and thus it was argued that the claimant did not even raise any question as to demurrage in the review meeting, and thereby the VPCL waived the claim of demurrage. Then again, it was argued that although no notice of 30 days as contemplated in clause 5.12 of the STA was issued by SAIL for storing of excess cargo, VSPL went on storing excess cargo without refusing to store such excess cargo. We would like to quote the exact argument in this regard from their written notes. The obligation of SAIL to give a prior notice of 30 days is limited to VSPL's obligation to stack such cargo in an orderly manner. The failure to give such prior notice of 30 days would entitle VSPL to refuse stacking of excess cargo. The instant case, VSPL no doubt stacked the excess cargo even in the absence of the notice. Two admissions of the respondents have emerged from the above. First, the claimant indeed stored excess cargo, and the second, that the respondent did not issue any notice as required under clause 5.12 of the STA. We are not at all unmindful that regarding excess cargo, the case of the respondent is different. However, in order to fortify the case, the respondent cites two cases, Prabhas Chandra Dolui Supra and BL Sridhar Supra. In Prabhas Chandra Dolui's case, it was held by the Honorable Apex Court that the essential element of waiver is that where there must be a voluntary and intentional relinquishment of a known right, or such conduct as warrant the interference of the relinquishment of such right. It means the forsaking of the assertion of the right at the proper opportunity. It was also held that in case that waiver is distinct from estoppel, in waiver, essential element is actual intent to abandon or surrender a right, while in estoppel, such intent is immaterial. The necessary condition is the detriment of the other by the conduct of one stopped. An estoppel may result though the party estopped did not intend to lose any existing right. Thus, voluntary choice is the essence of waiver, for which there must have existed an opportunity for a choice between relinquishment and the conferment of a right in question. In the case of B.L. Sridhar, plaintiff, the father of the appellants, had given consent to a certain consent to regrant of certain lands in the name of one of his sons alone, and the said son later sold part of the land to the respondent alienee or alienee. I'm sorry, Millet. 10 years later, the father filed a suit seeking declaration that he was the absolute owner of the suit land and injunction against the alienees, restraining them from interfering with their peaceful possession. The Honorable Supreme Court, confirming the judgment of the High Court, held that the appellant are bound by the principles of estoppel. It may be mentioned that in the case of B.L. Sridhar, the case of Prabhash Dolui was referred by the apex court. Now, let us see. May I take 5 minutes break, Millard? Just 5 seconds break, Millard. I'm sorry.
Yes, yes. Have your water here, Mr. Kosha. Sit down. Sit down so that we can't
Millard,
see.
I cannot do so, Millard. I cannot do so, Millard. Never been taught like this, Millard.
I'm rather tempted, Millard, since he's taking a break, I'm rather tempted to say this is not what I cited one more judgment. The classical definition of waiver is by Honorable Justice P.B. Mukherjee. In one sentence, waiver means consciously giving up a known legal right. Classical, when one sentence, 54 Calcutta.
Especially 16 for it is the Calcutta. Yes, yeah. চয়নের ম্যাটারটা অ্যাপিল ফ্রম অর্ডার আমি যেখানে জানতে বাট এদিক থেকে বেরিয়ে যাবে
Tomorrow my case to Monday I'm not here. Claims in this regard. The learned advocate for the claimant in his written notes of argument stated that their endeavor was to resolve the issue rather than go for litigation, as both the parties need each other for operations at the port. It is also stated that the claimant regularly persuaded the respondents through various correspondences from May 16, 2009 onwards till December 2010, keeping them informed about the excess storage of cargo beyond free period. And ultimately on December 20, 2010, Vide Exhibit C51, the claimant put the respondent on notice of their claim, which was before the first term of the contract had expired. And thereafter, the lawyer's notice was issued on 15th December 2012, before the expiry of the first extension of the contract. It is again stated the respondent also extended the contracts even after the arbitration was invoked, clearly supporting the theory that both parties needed each other and the intention was to solve rather than litigate about the issues at every stage. In the backdrop of the other, we may hark back to the decision made in the case of Prabhash Dolui. The Apex Court, while interpreting the Section 8 of the Transfer of Property Act, made the following observation. The best interpretation of a contract is made from the context. I was just mentioning that, Millard, while reading a contract, Millard, we have to go by the literal sense of the words spelled out in the terms of the contract, Millard. Every contract is to be construed with reference to its object and the whole of its terms. The whole context must be considered to ascertain the intention of the parties. In the instant case, beside what is in the contract and conduct of both parties must be taken into reckoning in determining the application of waiver. Hence, here the claimant considered the respondent a valued customer, and it is also repeatedly admitted by them, which eschewed from them from going into litigation outright. Instead, they kept the respondent informed about the excess storage possession of cargo constantly. And waiting up to the last moment, the claimant used the notice claiming their statutory rights in terms of the TAMP order. Thus, facts of the instant case are distinct pari materia from the facts of the two case laws, namely Probhas Dolui and BL Sridhar Supra. Moreover, even if the arguments of the respondents counsel is senior counsel is accepted, argumenti causa, that the respondent had acquired a right applying the principle of waiver, there appears absolutely nothing before us. Nor they did claim also that they had never exercised that right and gained or lost anything. On the point of 30 days notice, it is pertinent to consider clause 14.5 of Exhibit C22 STA. It reads as under: amendments and waivers. No amendment or waiver of this agreement shall be binding unless executed in writing by the parties to be bound thereby. No waiver of any provision of this agreement shall be deemed or shall constitute a waiver of any other provision, nor shall any such waiver constitute a continuous waiver. Quotes close. A perusal of the above excerpted provision shows that no waiver of the agreement is binding on the parties unless given in writing. No provision shall be deemed to have been waived continuously. In view of the above provision, the respondent cannot validly plead any waiver on the point of 30 days notice. Thus, we are of the considered view that the principle of waiver is not applicable in the instant case. Accordingly, all these three issues are decided in favor of the claimant, as there appears nothing that this tribunal this proceeding is barred under the rules and regulation framed by the TAM. It appears further that there is no breach of contract from the end of the claimant. Rather, there is a breach of contract by the respondent. Then issue number 6 and 7 was taken up, Millard, together, Millard. This is a relevant. I will also, Millard, read out certain portions of this, Millard. Propose the first issue is paragraph 84. I am, Millard, placing. It is the case of lease. It essentially depends upon the construction of Exhibit C22 ex facie. Exhibit C22 is a short-term agreement. It does not specifically show that it is a case of lease transaction, nor does it contain any specific provision in regard thereto. Notwithstanding the nomenclature of the document as short-term agreement, the provisions of the agreement shall be read together and construed to discern the nature of transactions as intended by the parties thereto. The description of the claimant in the preamble portion thereof shows that the claimant is a licensee and the Vishakhapatnam Port Trust is the licensor. It further shows that an agreement dated 31/1/2005, referred to as the original agreement, was entered upon by and between the claimant and the respondent for rendering integrated terminal services at EQ8 referred to as berth at Vizag Port for handling coking coal and metallurgical coke with stipulated draft of 14 meters. Since the requisite of draft of 14 meters could not be achieved to berth fully laden Panamax vessels after due negotiation, eventually the instant STA was executed on 6th of May 2008 for the same purpose. The avowed purpose in having entered into this agreement was for rendering ITSC, that's ITS Integrated Terminal Service, at multi-purpose berth EQ8 of the claimant for handling coking coal and metallurgical coke of the respondent, and in return thereof to collect the ITSC, the Integrated Terminal Service charges. Essentially, it is an agreement to render port-related services at the terminal and to collect the Integrated Terminal Service charges. What comprises Integrated Terminal Services and what is meant by ITSC, and what are the responsibilities or obligations to be performed by each of the parties there to have been elucidated under the relevant provisions inter alia therein. Exhibit C22, that is STA, contains 17 clauses and 2 annexures. One of them is a significant are the clause 1 to 6 and annexure 1 thereof. Clause 1 postulates the broad framework of the agreement applicable to the claimant and the respondent. Clause 2, the interpretation clause. Clause 3 thereof deals with the detail of berth and facilities. Clause 4 mentions about the responsibility of sale. 5 mentions the responsibility of VSPL. 6 deals with the schedule of rates. Annexure 1 shows the rate schedule of ITSC. The integrated terminal service charges is to be rendered by the claimant in terms of clause 1.1a to Q are unloading of the coal from Panamax at EQ8 berth of the claimant by using shore handling system, transportation of cargo, unload from the hook point to stockpile area, reclaiming the cargo from stockpile by using shore handling system, and mechanized loading of cargo onto railway wagons after weighing, photographing, lime spraying, dust suppressing, etc. For that purpose, the respondent assured 1.5 million metric tons of cargo per annum to the claimant, which is defined under the expression cargo commitment by sale to VSPL. If the cargo commitment of 1.5 million metric ton per year falls short for any reason, the respondent shall pay penalty at the rates mentioned inter alia in the agreement. On the part of the claimant, it is promised to discharge cargo brought on the ship at 22,000 metric tons per day. And if this discharge rate falls short of, the claimant shall pay penalty to the respondent. The respondent shall pay the ITSC at 167, etc. Then clause 2, the interpretation clause, I'll skip that. Paragraph 88 is relevant, because another limb of the argument of the respondent was rather that the agreement is really a lease agreement to be looked to in a different context. It is kind of a lease agreement, so they are already collecting ITSC. They are not entitled to collect any further charges. I'm sorry,
as a matter of fact, have you paid demurrage to VPT?
That I had to take instructions. Probably yes, I will take instructions on that. Must be because my understanding is I have to take instruction. I'll come back with that instructions.
Was it under a lease that you were holding the land in question under VPT?
Yes. That is a 30 years lease. I think we disclose the document in the arbitration, but we can disclose that document, and that has been mentioned in the award as well, because it's a licensor is the VPT. I am the licensee of VPT. There's a 30-year lease agreement, and then I step into the shoes and then I give out.
If you're a licensee, where's the lease?
That is what has been.
The
But
license.
there is an agreement of 30 years, my lord. I will disclose it. If your lordship so wishes, my lord, I will disclose that document.
I'm asking, just take instructions.
I will.
Yes.
I'm sorry, my lord. Built operate transfer, yes. But it is visibly clear from the above excerpted provisions that the entire 40,500 square meters of area are sure to be utilized for rendering integrated terminal services is a custom bonded area consisting of various structures mentioned in the expression terminal. What is more significant is that the claimant under this clause has confirmed that 40,500 square meters of area would be utilized for handling the cargo. The expression terminal is sought to be defined in clause 2 of the STA. It reads as under. Terminal means superstructure of the berth, wharf area, backup area, material handling equipment, unloaders, conveyors, stacker, reclaimer, etc. All these technical terms have been mentioned and emphasis supplied, Malad. Therefore, the stockpile area also comes within the definition of terminal at which the claimant is expected to render services to the cargo owners and collect ITSC. It is appropriate at this juncture to consider clause 1D, which may be quoted here under thus. Transportation of cargo from hook point to stockpile area and reclaiming of the cargo from stockpile with shore handling system. Thus, it is preeminent that the stockpile area where the cargo is expected to be stacked or stored is a part of the terminal. The cargo shall be reclaimed from there by using shore handling systems so as to load on to the wagons for transshipments to various destinations at the direction of sale. Malad, I'm not placing any four more lines, Malad. Obviously, therefore, the claimant cannot part with possession or control over the same. The claimant must invariably have access to it for storing cargo and reclaiming the cargo by using shore handling system and loading it on to the wagons for shipment. The de facto and de jure possession of the stockpile area will be with the claimant unless the claimant specifically parts with the same. Apropos clause 5.12 of the STA quoted ante, it shall be the responsibility of the claimant to ensure storing of cargo up to 60,000 metric tons, and in case of exigencies, to try to accommodate cargo for a further 30,000 metric tons for a period of continuous 15 days. If the possession or control over the stockpile area is parted with or given to the respondent, the claimant cannot perform this obligation. Clause 6 postulates the scale or schedule of rates, the integrated terminal services charges, etc. Then paragraph 93, to buttress the plea that it is a transaction of lease, the respondent seeks to rely upon Annexure 1 attached to Exhibit C22 STA and certain excerpt from the TAMP orders. Annexure 1 to Exhibit C22 deals with the rate schedule of ITSC. Clause 1 therefore reads that the ITSC for the guaranteed cargo quantity of 1.5 million per annum metric tons per annum shall be 167, including power element, etc. for the first year. Clause 2 thereof reads as under. The ITSC comprises various elements, both escalable and non-escalable, as bifurcated in clause 6 here and below. The ITSC shall be subject to such escalation, if any, at the beginning of each subsequent year of operation, except for royalty lease rental and power, which shall be on actual as per VPT notification and Andhra Pradesh Regulatory Commission notification respectively, on the basis and as provided in clause 6 herein below. At the beginning of each subsequent year of operations, the escalation in the ITSC shall be worked out on the basis of and as provided in the said clause 6 herein below, and the escalated rate of ITSC applicable for that year of operations so worked out shall be applied and be payable by sale to VSPL, my lord. Then, my lord, paragraph 94, I am not placing, my lord. They have this chart which I relied upon, my lord, earlier, my lord, that has been, my lord, given, my lord, set out, my lord. Now, my lord, I will, my lord, right away, my lord, go right at the bottom, my lord. Para 95, I am not, my lord, placing, my lord. Penalty committed cargo rate falls in short, my lord. That has been enumerated, my lord. Paragraph 97, my lord. No escalation can be considered in respect of non-escalable element. A close scrutiny of this table containing the data in conjunction with other clauses in Appendix 1 of Exhibit C22, that is the STA, would reveal that the elements of expenditure to be incurred by the claimant which are considered for fixing the ITSC are of two types, escalable and non-escalable. And in respect of escalable elements, in the event of escalation due to the notification is issued by the respective authorities or due to the increase in the price owing to WPI, the integrated service charges shall also be increased commensurately at the percentage given in the table. In respect of non-escalable elements, there is no change. Therefore, Annexure 1 fixes the rate of ITSC. It provides for a provision of escalation, price payable towards power charges, royalty, lease rental, other escalable elements owing to the increase in wholesale prices, my lord. Then, my lord.
What are you reading?
Paragraph 98, my lord.
Come to 103 and 104.
103 and 104. I have marked them, my lord. But in Exhibit R1, the TAMP notification dated 15/4/2009 under clause 3.5 thereof at page 110 of the respondent's spiral book containing the statement of defense, it is mentioned thus: if operational area is leased out on rental to the user, demurrage or of cargo stored therein shall not be levied again. What emerges unequivocally from this, that if the operational area is leased out by the claimant in favor of the respondent, demurrages are not payable. But in the absence thereof, demurrages shall be paid in an inescapable conclusion. Therefore, the transaction of the lease in sine qua non to escape from the liability of payment of demurrages, my lord.
Now, only just tell me,
yes,
this is very clear what the TAMP notification says. If you have leased out the portion to sale, obviously you can't claim demurrage because you have created an interest in land.
Correct.
They can keep for as long as they want
Absolutely,
to. But in the absence of lease, you can charge demurrage. There is no lease here.
No lease, yeah.
So you would say I can charge demurrage, the TAMP notification.
And I have not leased out the premises to respondent at all. I am holding the premises.
That's what I'm saying.
I'm sorry, Milord.
Had you leased out, then you couldn't have claimed them.
Absolutely not, and that is abundantly clear also, Milord.
Now, how far is this stamp notification authorizing you that will bind them? Because the contract otherwise, contract between the two of you, does it have any clause authorizing or empowering you to impose demurrage on them?
Technically, no, but on the reading of 5.12, Milord, that minimum guarantee cargo, my lord, which they are supposed to provide, as well as the other three documents which has been relied upon, which forms an integral part of the contract, my lord. It speaks about the terms and the regulations, as I was mentioning, my lord. The regulations has to be followed, the statutory obligation. So the statutory obligation operating within the port premises, my lord, in my respectful submission, if I operate within the port premises and I know I'm not adhering to the conditions as stipulated.
Therefore, what assumes great importance in this respect is whether you have had to pay demurrage.
I already have made a point, my lord.
If the answer is no, then we may not allow you to recover demurrage.
Possibly yes, possibly yes.
We fully appreciate if you had to pay demurrage for their fault, they should compensate you.
Precisely. I will get that in.
Mr. Riju Ghoshal, former learned senior advocate representing the appellant, begins his opening submission but does not conclude. Paragraph. When?
Wednesday, my lord.
এটা কি মানডে হবে না? এটা কি নন কমার্শিয়াল কি?
It's a non-commercial original side, non-commercial. Wednesday are the days, my lord.
Did it remain in the list on Monday, or you are in difficulty on Monday?
I'm not here on Monday, my lord.
Wednesday করে দাও। Huh?
Monday is usually a commercial day for your lordship. Monday and Friday, I believe, my lord. But I am not here on Monday. Otherwise, I would have done it, my lord.
Oh.
Next Wednesday কত?
Obliged, my lord.
আমি 20th
Deputy